Yes.
I may be permitted to move one unlisted motion at two, my lord.
Unlisted motion today. Why?
Some urgency is there, my lord. It is regarding the contract matter, my lord. May it please, my lord. May it please, my lord. I'm sorry. Admission, my lord, 24th.
20,
Analogous matter.
24th.
May it please, my lord, I'm like to mention a matter for listing for motion tomorrow, my lord.
Motion.
Tender matter, my lord.
Okay.
Tomorrow, my lord. Deeply.
Please, Your Lordship. Lordship, I'd like to mention item number 21 of part 2 hearing process.
Part 2. How am I going to reach? Part 2.
Part 2,
We have 16, 17 matters.
20,
21.
21, yes.
You want it to be
Lordship,
done today.
Dr. Ashok Sharaf is arguing in this matter. Dr. Ashok Sharaf is arguing in this matter.
Who?
Dr. Ashok Sharaf.
It is in part 2.
Part 2 hearing process.
Let's see when the part 2 comes. It is not given here, no?
May it please, your lordship. My lord. Item number 12, my lord. Can it be taken in at 2 p.m., my lord? Item number 12. Can it be taken at 2 p.m., my lord?
Why?
Lordships in the
Okay.
second half, my lord.
Before that, if we can try.
My lordships. I'll be there, my lord, but I have informed the councils for the other side, my lord, that it will be taken. I'll pray for 2 p.m.
You don't pray before the court by making already an understanding with your colleague. We'll see when the matter is taken up. Anyways, the court is rising at 3:15.
In item number 11, your worship. Item number 11, your worship.
7.
Respondent file an affidavit in opposition, your worship.
You are for the
I'm for the petitioner, your worship. Can it be on 24th, your worship? In the meantime, I will file my reply, your worship.
why the matter has come up today on a Tuesday? There must be something important.
No, this is contempt petition, your worship. Contempt petition, your worship. Honorable court order is to pass the.
We'll see when the matter is taken up.
Please, your lordship.
Your Lordship, I'd like to mention item number 16.
16. Yes.
Your Lordship, with the consent of the other side, Your Lordship, the leading counsel, Mr. R.V. couldn't come to court today because he's suffering from viral fever. 2 days accommodation may be granted, Your Lordship.
Don't ask for adjournment for 7 years old matters. Let's see when the matter comes.
Your Lordship, all the orders have been complied with and the back pages have been paid
Which one?
in this matter, Lordship.
17.
16.
16. What do you want?
So,
Adjournment. Why? 2017 matter. No adjournments.
item number 1 from the list.
Yes.
Please, my lord, I was engaged just recently. Your lordship had partially heard the matter, but
I hope so.
the last occasion. Of course, another set of counsel that appeared for them.
It's a suit for specific performance,
For specific performance,
which have been decreed.
which has been decreed, my lord. And initially it was dismissed by the trial court, my lord. And then the appellate court reversed and found that the plaintiff was entitled to specific performance, my lord. But thereafter, my lord, this appeal was preferred, my lord. Now, one vital aspect that was probably not pointed out, I mean, not even discussed, it was pointed out that this arrangement was in the nature of a distress selling. In fact, the plaintiff had admitted that I was in dire need of money, which is why I had entered into that agreement. And
It's everywhere. In
No.
all agreements, it is written
Lord,
that I am in need of money. That is why I have entered into. In all sale deeds,
Lord,
it
it
is
has come
written
in
always.
evidence. Lord, there are special circumstances which have come in evidence that with that money, I had again entered into an agreement with another person, and I paid from that. The plaintiff himself admits that out of the advance consideration, I paid a certain sum to the other vendor, Manoj. And I say, since he did not pay the balance, there was a specific window of 45 days, Manoj. And he says, Manoj, that I say, since he did not pay me the money, I could not conclude the other sale, Manoj. That is something which was admitted by the plaintiff. Now, and now, Manoj, more importantly, to
Yes.
show that he was ready and willing, Manoj, the plaintiff alleged that he issued a notice right after the completion of 45 days, which the plaintiff again denied during cross-examination.
Tell me the facts. What has happened? What?
Manoj will have the plaint at page 10, Manoj. Now, Manoj, para 2, that the defendant, along with his mother, namely Sumitra Rajvanshi, proposed 110/2006, proposed on 110/2006 to the plaintiff to sell out 1 kotha 5 lachas of land, standing in Dag number 68, covered by Patta number 41 of Revenue Village so and so, under Moza Bongaon, due to dire necessity of money. Your Lordship will see that the plaintiff is also in need of land, and as such, both the plaintiff and the defendant, along with so and so, decided to sell and purchase 1 kotha 5 lachas for a total consideration of so much, and executed on registered on so and so. So 1910/2006, the agreement was executed, Manoj. That particular agreement had a clear stipulation that the balance would be paid within 45 days. In fact, the agreement was also annexed, Manoj. Para 3, if your Lordship kindly sees, that's important because he claims to have issued a notice.
So the 50% of the sale has not been done by the defendant.
That not been done by the defendant.
Half of it has been done by the.
The mother has executed the sale deed. Now, here's a case where the mother has come in favor of the plaintiff. She's a stepmother, of course, and she says that I have not executed my part, and so insofar as her part is concerned, she's already sold it off.
Her part, she has sold it.
She has sold
You have not sold
I
it.
have not
So
sold.
obviously, there is no denial to that. That
Yes,
is why the suit for specific performance was.
Now, in para 3, Manoj, he makes a specific allegation that on 17/11/2006, he had issued a notice. Now, this notice, there was no proof of dispatch or receipt annex, my lord. He just said this is the office copy of the notice, and this notice was given perhaps to show his readiness and willingness that immediately after expiry of 45 days, I had shot that notice. Now, that notice is also annexed, my lord, and the PW1 in his cross-examination admits that he did not actually send a notice. And that was my specific case, that no notice was sent. This is just a ruse to kind of show that I was ready and willing. I issued the notice on time. But he, however, sues after 2.5 years.
2.5 years.
Yes. Now, your lordship is aware, now the Supreme Court has also clarified, just because it is within the limitation period, because this is under the old act where 20 is discretionary again. And just because it is within limitation, it doesn't mean automatic decretal of the suit. The time has to be accounted for. And if it is in contradiction of the clear terms of the agreement, all the more so, my lord. Now, my lord, agreement, if your lordship sees, my lord, that is page 22. Because the vernacular, because that's one. Page 24 is that stipulation. I'm taking your lordship to the vernacular copy because not be lost in translation. Page 24, if your lordship says.
Yes.
Page 24, somewhere in the middle, my lord, just after 80,000, those are numerics, my lord. Nogod, 80,000 taka, Agdhon Lolu. Now, thereafter, my lord, প্ৰকাশ থাকে যে বাকী টকা আজিৰ পৰা 35 দিনৰ ভিতৰত জমি বিক্ৰী ৰেজিষ্ট্ৰি কৰি বৰাবৰে সমুদায় টকা আদায় দিব লাগিব। Now, my lord, reading this sentence, my lord, it may give my lord, it says বৰাবৰে সমুদায় আদায় দিব লাগিব, and it says registry কৰি, my lord. Now, we have pleaded in our evidence, and we stated in our evidence that he took the responsibility of getting all the documentation done, and we had also signed. We had given him sign, and that is all the more clear from the following sentence, my lord. If your lordship sees, উল্লেখ থাকিল যে বরাবৰৰ জমি বেচা কিনা কাম জমি ৰেজিষ্ট্ৰি কৰাত আমি সন্মতি দিম। So he takes the initiative, we ratify. So my lord, it says
Read it again.
my lord, বরাবৰৰ জমি উল্লেখ থাকিল যে বরাবৰে জমি বেচা কিনা কাম জমি ৰেজিষ্ট্ৰি কৰাত আমি সন্মতি দিম।
Means he is going to the seller.
Yes.
Is going to give all the.
We consent that
Yeah.
he does it and we will give a cooperation.
Hmm.
Now, our
But obviously, the registry has to be done by you.
registry, my lord, here that is what.
It has to be
ultimately I have
signed by
sign.
you.
That is, but
Yeah.
probably this is what.
Mr. Deka, you don't have other case. You are now coming up with the recent judgment of the Supreme Court wherein it says maybe 3 years is the limitation, but if a person does not come immediately
Yes.
within that time, then
Right.
the discretion should not be
Right.
exercised.
Right.
That is your point at best.
That is my point. And additionally, my lord, now because your lordship will also see, because I have to dislodge that presumption of time not being the essence, my lord. So therefore, my lord, this 45 days was a clear stipulation, my lord. And during evidence, my lord, he has admitted, PW1, that out of first of all, now coming back to the point of notice, my lord, here he says it says 45 days, my lord. So he very cleverly, my lord, he annexes office copy, a purported office copy of a letter on 17/11/2016.
Over.
Now during
Let's see how have you cross-examined him
my lord,
on that. I'll do it.
cross examination. W1's cross-examination. Second page, probably page 10 of that file, Manoj.
Read the cross-examination of the plaintiff, DW1. Of DW1. Your cross-examination.
মই আদালতত দিয়া সাক্ষ্যনামা পঢ়িব নাজানো। সাক্ষ্যনামাত মোক বিবাদীয় অসমীয়াত বুজাই দিয়ে যে মই সেইমতে চহী কৰিছো। মই মুঢ়া বনাই বিক্ৰী কৰো। মই মুঢ়া বনাই বিক্ৰী কৰো। মই ওচৰীয়া জমি পৰিয়ালটো চলাইছো। 19/10/2006 তাৰিখে মই এখন বাইনা পত্ৰ চুক্তি কৰিছিলো। বাইনা যৌথভাৱে মই আৰু মোৰ মা সুমিত্ৰা সোৱনশো ৰাজবংশী আৰু নগেন চন্দ্ৰ দাসৰ লগত সম্পাদন হৈছিল। মই এজাহাৰ দিছিলো, কিন্তু পুলিচে একো এজাহাৰ সংক্ৰান্তত কাম নকৰিলে। প্ৰথম অৱস্থাত চুক্তি সম্পাদন কৰি 80,000 টকা নগেন দাসে মাক দিছিল। গৈৰ পৰা 40,000 টকা মই পাইছো। চুক্তি পত্ৰ পঞ্জীয়ন কৰোঁতে কৰিছিলে। এই টকা মোৰ ঘৰৰ পৰা কিছু গাঁৱৰ মাটিত কিছু আঁতৰত মাটি বাইনা কৰিছিলো। এই টকা পোৱাৰ পিছত মোৰ ঘৰৰ পৰা কিছু আঁতৰত মাটি বাইনা কৰিছিল। This is he stated, he reiterates his chief. মই
কোন তাৰিখত
বাতিৰ ওচৰত টকা বিচাৰি গৈছিলো মোৰ মনত নাই। মোৰ মাক অংশীদাৰ
সতীয়া মাক
অংশখিনি 12.5 লেচা জমিৰ বিক্ৰী কৰি বাদীক দলিল কৰি দিয়ে। সেইটো সত্য নহয় যে বাদীয়ে মোৰ ওচৰত এই পাব লগা টকা দিব বিচাৰি
পইচা-
দলিলৰ বাবে বহুবাৰ গৈছে। এইটো সত্য নহয় যে বাদীয়ে যেতিয়া মোৰ ওচৰত বিক্ৰী দলিলৰ বাবে যায়, মই বহুবাৰ সাল সলনি কৰিছো। বিবাদীয়ে জমিত কৰা ঘৰ চুক্তি আদি ঠিক ঠাক কৰিছে, লগাই ঠিক ঠাক কৰিছে।
বিবাদীয় মাটিত
বিবাদীয় মাটিত থকা ঘৰটো উক্ত আদি সোণ আদি লগাই ঠিক ঠাক কৰিছে। মোৰ সাক্ষ্যনামাৰ লগত দিয়া দলিল প্ৰদৰ্শ অমুক অমুক। For a moment, PW wants their logic.
মোৰ নাম এইটো মোৰ When did you receive the money?
1/10/2006.
Huh?
1/10/2006 on the day. $1910. Oh, sorry. But I have said my stepmother received the duty. But if I may just refer to PW1's portion.
He did not enclose any agreement.
My lord,
You did not. Then
My lord, he admitted.
what?
PW1 admitted
Regarding what?
that I am using that money to buy another plot.
Who?
The plaintiff admitted.
How does it matter?
My lord,
You are to prove the document.
my lord,
If you have any agreement.
see the plaintiff. My lord. PW1's
You know, when did
cross-examination
you enter into an agreement? You don't know. You don't say when it is. Normally, it is there is nothing out there.
My lord, he has admitted that it was in dire need of money. He also says that I know he wanted to buy land elsewhere.
On one hand, you say you were in dire need of money. On one hand, you say, have you seen your evidence on affidavit? On your evidence on affidavit, you categorically say, that, yes, initially I did not want, later on account of threat and here. Then I gave every permission, everything, so that it can be done.
Yes.
Then he said, you say that you have been visited the plaintiff for the money and the plaintiff did not. When you are being asked when, you don't remember.
Now, my lord,
Then-
my lord will kindly see
Why should we
PW1.
interfere?
My lord will kindly see PW
100.
extracts.
Let us see what is wrong with the order passed by the
My
division.
lord, order, my lord, the court has not taken into account all of this, my lord.
What? What it has not taken into consideration?
That he denied the notice itself, my lord. He says,
How is it relevant?
my lord, it is very relevant. Why,
That's
my
not
lord?
relevant.
My lord, PW wants cross-examination for a moment, my lord.
No.
I'll
Nothing
just refer to
no,
four
no,
portions
no.
from
I'm
that
not
cross.
sitting in first appeal.
No, true, my lord, but this
No,
was
no.
not taken note of, which is why I'm saying it's perverse.
Oh.
For a moment, my lord, PW wants cross, my lord.
When was the suit filed?
Eight, my lord, 22/5/2008. My lord, I'll just read that portion. Gusoria, my lord, this is by the plaintiff himself, my lord. Gusoria matir babot মোৰ পৰা টকা লৈ বিবাদীয়ে অন্য ঠাইত মই মাটি কিনাৰ বাবে ইমান হাজাৰ টকা এডভান্স হিচাপে এজন মানুহ অন্য এজন মানুহক দিয়া বুলি মই জানো। চুক্তিপত্ৰ মৰ্মে 35-40 দিনৰ ভিতৰত 35 দিনৰ ভিতৰত ইমান হাজাৰ পাছত দিব পাৰে যদিও ইমান 3 বছৰ পাছত মই এই গোচৰটো দিম।
Huh?
He says 3, of course it's 2.5, my lord. Then my lord, এই গোচৰটো কৰাৰ আগতে দলিল সম্পাদন কৰি দিব লাগে বুলি মই বিবাদীক নোটিছ দিয়া নাছিল। Now, my lord, why I'm saying harping on this is because of this, my lord. Now, if time is the essence of the contract, the main vital issue is who did not come forward. Now, I had my own reasons for the sale to conclude in time, my lord. Because with that money, plaintiff also admits, I was planning to buy another plot of land. So
So for that, you have to show your agreement for sale. These are the, no, you have to show. Is it verbal?
but since it is
No,
admitted,
he is not a party to that.
it's
The
not
plaintiff, no, the plaintiff is not a party to that. He may have heard. It's hearsay.
true, my lord.
So
but-
how is it relevant?
My lord, everyone had, there is in fact no dispute to the fact that with this money I had to buy another plot of land, my lord. Now, therefore, the question was, who was responsible for this delay beyond 45 days? Now, it is plaintiff's suit.
Who is responsible is not a question on 100 to be decided.
I'll come to that, my lord. Now, my lord, the plaintiff
Enough.
to say.
No more. I think this is now to dictate.
My lord,
No.
my lord will allow me,
Now think about the cost
my lord will allow
of
me to place the
troubling the
judgment.
plaintiff so long. Pay that 40,000 back as cost. Your appeal should be dismissed with cost of 40,000 which you received. That is a better option.
My lord, I will
Nothing
allow
more.
me to place the judgment. My lord, I will just engage.
Judgments are there for the Supreme Court to look into, not for me.
My lord will at least see, my lord. Now, my lord, coming back to the notice part, why I say it is very essential is, now he wanted to show, it was his duty as a plaintiff to prove readiness and willingness.
In the cross-examination, did you prove anything as regards the notice? Was the notice exhibited?
That's the precise point, the notice.
Was the notice exhibited or not? Did you put it under objection?
I posed the
Did you put
question.
it under objection?
I didn't put
Then
it.
It is
My lord,
notice
I
is
was
there.
not agitating mode of proof at all, my lord. I
Did
was
you
saying-
say anywhere that you have not received the notice in
Yes,
your written statement?
Yes,
Where?
yes, my lord.
Let us see.
My lord will have the written statement. Para 4, my lord. That in response to the averment made in para 3 of the plaint, defendant stated that there was no notice served upon the defendant on dated 17/11/2006. Rather, the defendant was always insisting the plaintiff to pay the remaining amount as he was looking for purchasing another plot of land for his dwelling. So, my lord, the only document the plaintiff.
Now
had-
here kindly see. Let us go by your statement on affidavit. You were looking You did not enter into an agreement as on the date on which you have filed the affidavit.
This is.
No, this is when you filed your written statement. There was no agreement. It is admitted.
My lord,
It is admitted that
I said I was looking to purchase.
you are looking. You have not purchased or have entered into an
I have not
agreement.
purchased, my lord.
No. You have not entered
My
into
lord,
an
these are
agreement.
rural transactions, my lord, your lordship has seen
Rural
the,
transactions also, you would have said that I have found a plot of land to
now, my lord,
purchase.
now, my lord, first thing, my
Rural
lord,
transaction also
first thing,
you
my
would have
lord,
said.
I am the defendant, my lord. It was for him to show readiness and willingness, my lord.
His readiness and willingness is there on the statement out there, and along with that, that particular
My lord,
document was there.
The readiness
And he
willingness throughout-
purchasing it from his mother on 1/12/2007 clearly shows, and therefore the time limit which is there immediately thereafter. So this aspect of the matter can be very well taken
My
care of.
lord, one last thing, my lord. Now, my lord, the only thing to show, because his readiness and willingness and on the date of the filing of the suit will not be sufficient, my lord. He has to show that on that window of 45 days, he was ready and willing. And maybe immediately thereafter. To show that there is just one notice. That how does he demonstrate readiness and willingness? He gives a notice, and that's a clear backdated document, my lord. Does not contain a receipt. It does not contain an acknowledgement. And to top it all, my lord, during cross-examination, he admits that I did not send a notice, which basically means that from 1910-2006.
Let us see the read the entire cross of the plaintiff witness. The more you take, the 40,000 is there. Now it's going for another 5,000.
I committed to the brief after I.
Now it becomes 45. 40 has become 45. By the end of the term, it may be more than that. It gives you better than to appeal in before the Supreme Court. Yes, come up. Let us read the cross-examination of PW. The entire one.
Yes.
Is the deed name notice issued by the lead counsel for a year?
বিবাদীয় গুচৰীয়া মাটি মোক বিক্ৰী কৰিম বুলি পঞ্জীয়নভুক্ত চুক্তিপত্ৰ কৰিও মোক মাটি খিনি বিক্ৰী নকৰাৰ বাবে এই গোচৰ কৰিছো। 12.5 লেচা মাটি লৈ এই গোচৰ কৰিছো। চুক্তি পত্ৰখন 1 কঠা 5 লেচা মাটিৰ কাৰণে কৰা হৈছিল। 12.5 লেচা মাটিত বাবদ জুতিয়া সুমিত্রা রাজবংশী ৰেজিষ্ট্ৰাৰ দলিল কৰি দিছে। সুমিত্ৰা বিবাদীৰ মাক হয়। 1 কঠা 5 লেচা মাটি সুমিত্ৰা আৰু বিবাদীৰ জমি পাট্টাত মাটি আছিল। চুক্তি পত্ৰখন কৰোঁতে টকাখিনি সুমিত্ৰাৰ হাতত দিছিলো। Now there is a rift, my lord. I'll show PW3. The mother and the son have a rift, my lord. The stepmother and stepson. So therefore,
Not
that is
necessary.
another.
Not necessary. Reading your cross-examination, you categorically say that you have received the 40,000, and for which you were using that 40,000 for purchasing another plot of land. So forget about the rift.
12.5 লেচা
While entering, there was no rift. Did you file an FIR after the entering into the agreement?
I had lodged
When?
later.
Later, no. After entering into the agreement, that under threat you have done that.
Plea of undue influence, because that they did not have, my lord. They wanted to expand.
So
during
it
everything.
has to be everywhere. Okay, now it is 50. And 50 you have to share with your client now. 25 upon you.
My lord,
25 upon you. Rest, I would not burden your client further. Any further we go, it is upon you. Yes, come.
my lord,
Yes, further, let us go. 25 is in you. 12.5 লেচা মাটিত লৈ, then read it.
12.5 লেচা মাটি লৈ ৰেজিষ্টাৰ দলিল সম্পাদন কৰি হিচাপ অকল সুমিত্ৰা ৰাজবংশীয়ে চহী কৰিছে। চুক্তি পত্ৰ খন আদালতত দলিল কৰি দাখিল কৰা নাই আৰু বিবাদীয়ে চুক্তিপত্ৰখনত চহী কৰা সন্দৰ্ভত আদালতত মই কোনো দিয়া নাই। বিবাদীয় উক্ত 12.5 লেচা মাটিৰ বাহিৰে বিবাদীৰ উক্ত 12.5 লেচা মাটিৰ বাহিৰে অন্য মাটি নাই, আছে নে নাই মই নাজানো। নৰ্মেলত চুক্তি পত্ৰখন ইমান 12-10-2006 ইংৰাজী তাৰিখে কৰা হৈছিল। চুক্তি প্ৰথমতে ৰেজিষ্টাৰ কৰা হৈছিল। চুক্তি মৰ্মে বিক্ৰী দলিল চুক্তি পালন কৰাত 35 দিনৰ ভিতৰত সম্পাদন কৰা কথা আছিল আৰু ময়ো বাকী টকা বিবাদীক দিয়া কথা আছিল। So these are reciprocal obligations. মই পইচাটো দিয়াৰ বাবে ৰাখি আছিলো যদিও 35 দিনৰ ভিতৰত বিবাদীয়ে মোৰ ওচৰত হিচাপ আৰু দলিল কৰি নিদিলে বিবাদীয়ে মাটি বৰ্তমান বিবাদীয়ত দখল কৰি আছে।
Readiness, willingness. He had the money, but he did not do it.
Not now, my lord. At that
Point of time, readiness and willingness was there.
my lord, to show that there's just the notice.
Forget about the notice. This is the evidence. Forget about the notice. Let us not go into the notice. This particular statement which has come up in
But
cross-examination.
he has to explain this delay. My
This
lord, as
is
per
it.
the recent
No, he has done it.
My lord,
He says that I have kept for 35,000 rupees with
my
me.
lord, did he get the permission? Because as per the contract, my lord, he has to do all the necessary paperwork, my lord. Where is that evidence?
Did you raise anything about your permission? He did not get the permission?
Yes, my lord, I said
Where?
I achieved.
Where?
I said that I said I had submitted all things for him. It was for him to show readiness and willingness.
Is it your statement out there that they did not get into all these things, that there was no permission sought
Well,
for?
I have said he did not even come with the money.
Yes.
And going by the
Yeah, hope.
sequence,
55. 30 is on you. 30 to be deposited next week. 25 goes to that charitable institution. Put it in the charitable institution. Nowadays, I give it to the charitable institution. Give it to him. Let him, while I dictate, you choose where to pay.
they
To
are
which
fighting
charitable?
for 15.5 lakhs of land, my lord.
No, that is why I'm not burdening the client. I'm burdening you. Where you are going to pay 35,000. 20 is on your client, 35 is yours. The instant second appeal. Yeah, this is an appeal under section 100 of the Code of Civil Procedure, challenging the judgment and decree dated 13/7/2018, passed in title appeal number 11/2014 by the Court of the Civil Judge Kamrup at Amingaon, whereby the suit filed by the plaintiff, that is the plaintiff, was decreed. Thereby setting aside the judgment and decree dated 8/9/2009, passed by the learned Munsif number 4 Kamrup at Guwahati in title suit number 124/08. This court, by an order dated 26/11/2018, admitted the second appeal by formulating a substantial question of law, which reads as under. Order to the The question as to whether the said substantial question of law is involved in the instant appeal. This court finds it relevant to refer briefly to the facts which led to the filing of the instant appeal. For the purpose of convenience, this court refers to the parties in the oh, okay. The appellant herein was the respondent herein had filed a suit before the court of the Munsif number 1 Kamrup Metro at Guwahati, which was registered and numbered as title suit number 124/2008. The reason for filing the suit was that the plaintiff had entered into an agreement for sale, a registered agreement for sale with the defendant and his mother, one Sumitra Rajbangshi, for purchase of 1 katha of a plot of land measuring 1 katha 5 lechas at a total consideration of rupees 1,90,000. This agreement was entered into on 19/10/2006. The total 1,90,000. Out of the total consideration, an amount of rupees 80,000 was paid by the plaintiff to the defendant and his mother. It was stated in the said agreement. It was a stipulation in the said agreement that the sale deed would be executed, that the sale proceed, the sale of the land would be, that the registered deed of sale that the sale proceedings would be completed within 35 days on payment of the cash of the outstanding balance of 35 outstanding balance. Subsequent thereto, a notice was issued by the plaintiff on 17/11/2006 through his counsel to execute the sale deed and deliver possession of 1 katha 5 lechas of land. It was averred in the plaint that the said notice was duly received by the defendant. However, the defendant and his mother did not immediately execute the deed of sale. And it was averred in the plaint that on 4/7/2007, 7/8/2007, and 25/10/2007, the plaintiff requested to complete the terms and conditions of the contract. By receiving the remaining consideration. The mother of the defendant, however, executed her portion of the deed of sale, her part of the agreement by executing a deed of sale of 12.5 lectures by a registered sale deed number 374/2007, dated 1/12/2007, on receipt of rupees 60,000 as full and final consideration, and delivered possession to the plaintiff to the said extent. The plaintiff, however, the defendant did not execute the deed of sale for which the suit was filed. For seeking specific performance of the agreement for sale dated 19/10/2006. And for other reliefs. It is relevant to mention that as the mother of the plaintiff, the defendant, had sold half of the land, the suit was confined only to 12.5 lectures of land. The defendant, pursuant to receipt of the summons, appeared and filed a written statement. There was no denial to the execution of the agreement by the defendant, agreement for sale dated 19/10/2006 by the defendant, nor to the receipt of the part consideration. It was the specific stand of the defendant that the plaintiff did not honor his promise to pay the balance amount within the time stipulated. And as such, the defendant could not, for which the defendant could not purchase an alternative plot of land which he was looking out for. Based on the pleadings, the learned trial court framed as many as 6 issues. Issue number 4 relates to as to whether the plaintiff entered into a valid and enforceable contract by deed number 285/06/2006, dated 19/10/2006, with the plaintiff in respect to the suit land. And issue number 6 was whether the plaintiff is entitled to a decree for specific performance of the contract for sale as prayed for. The plaintiff in support of his case, examined as many as 4 witnesses, including the defendant, including and exhibited four witnesses, 3 witnesses, and exhibited various documents. On the other hand, the defendant examined as many as 4 witnesses and also exhibited certain documents. The trial court, by the judgment and decree dated 8/9/2009, dismissed the suit. By opining that as the plaintiff failed to pay the amount of rupees remaining consideration within 35 days from the date of the agreement, there was no cause of action for filing a suit seeking specific performance. Being agreed, the plaintiff preferred an appeal before the court of the civil judge at Kamrup at Aminga, which was registered and numbered as title appeal number 104/2009 and was subsequently re-registered as title appeal number 11/2014. The first appellate court, by the impugned judgment and decree dated 13/7/2018, decreed the suit in favor of the plaintiff. By holding inter alia that there was an enforceable contract between the plaintiff and the defendant. And secondly, the plaintiff was ready and willing to perform his part of the contract, and the defendant had avoided, and as such decreed the suit for specific performance. It is under such circumstances the instant appeal is before this court. In the backdrop of the above facts, let this court take note of the submissions made by Mr. B.D. Dekar, the learned counsel, appearing on behalf of the plaintiff, on behalf of the appellant, who is the defendant in the suit. To support that, that the substantial question of law which have been formulated by this court by the order dated 26/11/2018 is a substantial question of law involved in the instant appeal. Mr. B.D. Dekar, the learned counsel, submitted that though the plaintiff have averred in his plaint his readiness and willingness, but he has failed to prove his readiness and willingness in the context of the requirement in terms with the deed of agreement dated 19/10/2006. He submitted that though the plaintiff tried to show on the basis of the notice dated 17/11/2006 that he was ready and willing. But during his cross-examination, he has himself admitted that the said notice was not, that he did not know that he has issued this notice,
That's not.
that he has not issued the notice. He said, the learned counsel therefore submits that this aspect is a perversity which strikes on the issue number 5 as to whether the plaintiff was entitled for a decree for specific performance. In addition to that, the learned counsel also submitted that the agreement for sale was entered into on 19/11/2006. And the suit was filed on 28/5/2008. Isn't that the date? 22/5/2008. And as such, the learned First Appellate Court ought not to have exercised the discretion conferred upon it under Section 20 of the Specific Relief Act 1963. He submits that though in terms of Section Article 54 of the Limitation Act 1963, a period of 3 years is stipulated, but then also it is the well-settled principle of law that the suit for specific performance has to be filed at the earliest. And failure to do so, the exercise of discretion should not be made by the court. On the other hand, per contra, yes, madam, what do you have to say?
Lordship has already expressed the mind, Lordship, and willingness and was there, Lordship.
Oh, madam, don't forget. At the time of the delivering the judgment is a different thing. I
Yes,
express
Lordship,
everything.
willingness is there because the mother has done her part, Lordship. That is their Lordship. So they are living in the same property, Lordship.
Hmm.
He has knowledge that that part has already executed with his mother, Lordship.
Hmm.
So there is no question of non-willingness, Lordship,
Hmm.
because mother's part she has done. And as per perversity regarding the judgment of the appellate court, Lordship, all the issues has been discussed in that,
Now, regarding that notice thing, what he is saying,
Lordship.
he's saying something about the notice
Notice, yes, so in the
that you
PWD
said in your cross-examination that that
That-
notice was not
that
issued.
part, Lordship, what is there in the evidence, I cannot change, Lordship. But apart from the notice, the willingness, the main issue is that whether I was willing now ready to pay the amount or to execute the second portion of the contract, Lordship. It is evident from the plaintiff itself that mother has executed, Lordship. They are living in the same property. In his evidence, he's saying that I know that my mother has done her part. She has executed, Lordship. So there is no question of non-willingness, Lordship. That is my submission, Lordship.
Per contra, Ms. So-and-so, the learned counsel appearing on behalf of the respondent submitted that the substantial question of law so formulated is not involved in the instant appeal. in as much as the question of not the plaintiff having not willingness, readiness, and willingness does not arise. She submits that it is the mandate of Section 16C of the Specific Relief Act 1963 that the plaintiff has to plead and prove readiness and willingness. Drawing the reference to the plaint, the learned counsel submitted that the plaintiffs have pleaded it's his readiness and willingness. As regards the evidence, the learned counsel submitted that in the evidence on affidavit filed by the plaintiff as well as the other witnesses, it has been categorically shown that the plaintiff was ready and willing. She submitted that during the cross-examination also, nothing would be culled out, which would show that the plaintiff was not ready or willing. On the other hand, a reading of the cross-examination would also show that the plaintiff had categorically stated that he had kept the 35,000 with him. He had kept the remaining money with him to be paid within 35 days. However, the defendant did not receive. Adding further to her submissions, the learned counsel further submitted that in the instant case, it would be seen that the defendant's mother have executed her part of the deed of sale. And if that be so, the said aspect categorically shows that the plaintiff was ready and willing to perform her remaining part of the contract of the sale. As regards the submission made to the aspect that the plaintiff had stated that she had not issued the notice the learned counsel submitted that the notice was duly exhibited. The said notice was not put under objection, and as such, the said notice could not have been, and as such, the said statement would not in any manner show that the plaintiff was not willing or was not ready or willing to perform his part of the contract. Upon hearing the learned counsels for the parties, this court has given an anxious consideration to the upon hearing the learned counsel for the parties, perusal of the materials on record, as well as the evidence to which the counsels for both the parties have led this court to. It is apparent that there is no denial to the fact that there was an agreement for sale dated 1910-2006 for sale of 1 Qatar 5 lectures of land belonging to the defendant and her mother. The evidence of the cross-examination of the defendant categorically shows that he has also received part of the half of the 80,000, which was received in advance and had put to use that said amount. It is also seen from the materials on record that though the defendant have made a plea that he has entered into an agreement for purchase of an alternative plot of land, but there is nothing mentioned. There is no documents which have been enclosed to show, or there is no evidence to show the same. In fact, the pleading of the defendant is otherwise, wherein, inasmuch as he states that he was looking for another alternative plot of land. A further peruse, this court have also perused the evidence, the pleadings. And from the pleadings of the plaintiff, it is apparent that the plaintiff had pleaded his readiness and willingness to to perform his part of the contract. It is also seen that subsequent to the deed of sale, subsequent to the agreement for sale, the mother of the plaintiff, of the defendant, had sold her portion of the land. And this was sold on 1/12/2007. The defendant, the plaintiff, the sale made by the mother of the plaintiff, defendant to the plaintiff, is not in dispute. From the evidence of the plaintiff, it is also clear that he had categorically not only stated in his evidence on affidavit, but also in his cross-examination that he had kept the amount of the balance consideration to be paid to the defendant, but the defendant did not receive. This court also finds it relevant at this stage to touch upon the submission made by Mr. B.D. Dekar to the effect that there was a delay in, that the suit was not filed at the earliest, for which the learned trial first appellate court ought not to have exercised the discretion under Section 20 of the Specific Relief Act 1963. In the opinion of this court, the said submission is misconceived, taking into account that on 1/12/2007, the plaintiff, the mother of the defendant, had sold her portion of the sale and delivered the possession. And the remaining portion, and within 5 months thereafter, the suit was filed. The said, in the opinion of this court, is not a delay, is not such a delay which would disentitle the plaintiff to a suit to the relief of specific performance. Under such circumstances, this court further have also taken note of the judgment passed by the learned first appellate court. And a perusal of the points of the, and from a perusal of the said judgment, impugned judgment and decree, it is the opinion of this court that the learned first appellate court have rightly decided the suit in terms with the provisions of Order 41, Rule 31 of the Code. And as such, the substantial question of law, which was formulated to be involved in the instant appeal, does not arise. Accordingly, the instant appeal stands dismissed with cost quantified at ₹20 for him and 35 for you. Who? To whom are you going to pay? You are going to pay to some charitable institution. Whom? I gave you the name. Which one?
It will not record that, it will come across as I was wasting the court's time.
Huh?
It will not record that, but
Which one?
the cost is imposed on the council.
Yes, upon you. Then only you are going to pay 35,000 to whom? Which charitable institution? Do something good for spoiling the judicial time unless. With costs quantified at ₹11,000.
Lordship, there
What?
is a stay order operating, staying the execution. Lordship, IA is there. That may be vacated.
What's
400.
the LCR be returned? What's-
But one last thing, the appellate court did not specify the balance to be paid. That has to be paid. Right?
Oh, okay. It does not have any interference. This court, however, before parting, before parting, this court also finds it very relevant to take note of that the learned first appellate court, while decreeing the suit for specific performance, failed to exercise the powers under Order 20, Rule 12. Isn't that 12 or 12A?
I'll just- 12A, 12A.
12A, na? 12A. By fixing a date within which the plaintiff is required to pay his part, he's paid us the remaining consideration, the balance consideration to the defendant. In exercise of the powers under Order 41, Rule 33, this court of the code, this court affirms the judgment and decree passed by the learned first appellate court, subject to deposit of the balance consideration within how much? 30 days.
45 days. Lordship.
Huh?
45 days.
What? 15 days. Within 15 days.
No, Lordship, 30.
Within 15 days from the date of the instant judgment. $15. You are ready and willing. You said that you have the money in your pocket.
Lordship inclined to 30 days. Lordship inclined to say that.
7 days. 7 days. If within 15 days. Within 15 days. Or and if the defendant refuses to accept the said amount, within 7 days thereafter, deposit the same before the learned trial. With the above, the instant appeal stands here, whose appeal stands dismissed with cost quantified at rupees. Yes. In the peculiar facts of the case, this court is not inclined to impose any costs.
Deeply obliged.
Redundancy.
Model code of conduct matter, that was withdrawn matter. Thereafter, my lord, another tender was issued on my lord on 15/6/2024, my lord. And I have participated in the said tender, but subsequently, my lord, due to some technical reason, my lord, that tender was also my lord cancelled. And now, my lord, present tender, my lord, that was issued on my lord 8/7/2024, my lord. That is at page 44, my lord. Here, my lord, for some, my lord, clause, my lord, I have agreed, my lord, page 44, my lord. And basically, my lord, terms and condition number 4, 7, and my lord 21. 7 and 21, my lord.
Yes, what is wrong with 7, clause 7?
Clause 7 and my lord, clause 21, my lord. Here, my lord, it was my lord, for my lord, individual contractor, my lord, they have to my lord participate in for my lord, all the my lord GPSS, my lord, 21 GPSS, my lord. And for my lord, some other one class of contractor, my lord, they may put rate in particular my lord GPSS, my lord. And my lord, clause 21 says, my lord, so for my lord,
Would bid in respect to their own bid tag any GPS.
and clause 21 says, my lord, so far, my lord, individual contractors are concerned, my lord, their rate will be, aggregate rate will be taken. And so far, my lord, GPSs are concerned, my lord, individual rate will be taken. Here, my lord, the problem is that, my lord, there are 21 GPSs, my lord, some GPSs is located in, my lord, forwarded area, my lord, and many GPSs are located in, my lord, remote area, my lord, where, my lord, motorable road is also not there, my lord. We have to transport, my lord, for etc. My lord, block card, etc. And in those cases, my lord,
Why is that 136 rupees mentioned?
under the ceiling price, my lord, above that we cannot afford rate, my lord. So rate should be, my lord, below.
So you don't want to quote for some areas.
No, my lord, we are bound to, my lord, quote, my lord, 21, my lord, GPSs, my lord. If my lord aggregate is taken, my lord, then my lord, we if my lord aggregate rate is taken, my lord, then my lord, we cannot compete, my lord, in my lord, forwarded area. Suppose, my lord, in forwarded area, my lord, we can quote rate, my lord, 10 rupees per quintal per kilometer. And in, my lord, some backward class, backward area, my lord, we have to quote my lord, higher rate, my lord, per quintal, per kilometer, my lord, 40-50 like that, my lord. Then, my lord, if aggregate is taken, my lord, then we never, my lord, compete in, my lord, forwarded area locality, forwarded locality, my lord, GPSs, my
So
lord.
everybody is going to quote like that.
So, my lord, so far GPSs is concerned, my lord, they can quote, my lord, individually, my lord, in, my lord, particular GPSs, my lord.
So you mean to say the secretary of the GPS or WSA may quote bid
Okay,
in
okay.
respect to their own along with tag if any GPS.
They can choose, my lord, their own, my lord.
So they need not quote other 20 areas,
They need not quote, my lord, for 21, my lord.
but they can get for everybody.
But we have to, my lord, contact your, my like this, me, my lord, we have to quote, my lord, for 21, my lord.
What is this tender for detailed NIT for transportation of food grains, that is NFSA, in two tier 1 and tier Hosai for the financial year 2024-25? And the two comprising of
Our clauses are also, my lord, discriminatory, my lord. So far, my lord, clause
so
3.
the secretary of the GPSS can quote only for him.
For him and, my lord, along with, my lord, tag, my lord, if any, my lord, that's all. But in one, my lord, one side, my lord, there is, my lord, several.
Yes, Mr. Gogoi, what is this?
Lordships, regarding this, before that, my lord may kindly peruse paragraph 6 of the writ petition.
Paragraph?
Paragraph 6 of the writ petition. Paragraph 4 of the writ petition, sorry,
Four,
paragraph 4. 4 of the writ petition is page 6, Lordship.
Yes.
Was the tender issued on lordship on 15/6/2024 lordship.
I think
Exactly,
tender for, yeah. And what is the last date?
lordship, that tender was withdrawn lordship, cancelled. And the clause which was in the lordship, the present tender and earlier tender is exactly similar lordship. Only 2-3 words are included. I will specify the words lordship. Otherwise, in that particular tender, petitioner says participated lordship. At the relevant point of time, there is no objection from the petitioner side also lordship. And there is a, but no, it is not a case that it is isolated one or two participated. There is a participation is there in the 23 participated in the earlier tender lordship. And my lord may, for that purpose, lordship may kindly peruse page 42 lordship. Page 41 lordship, page 41 lordship.
Why was it cancelled?
Lordship may, point number 1 and 2 last paragraph lordship.
Where is the earlier
That-
tender?
that is on page 34 lordship.
It is the same tender.
Lordship. It's also a two-tier lordship.
And
Clause
and
and next, the present one is lordship in page 44 lordship.
no. Here you have added one thing in
Lo-
clause 21. You have
Lordship.
added in case of GPSS,
Lordship,
WSS, the L1 rate will be considered individual.
And then point number 7 also lordship. Point 3 also, 3
Point 3.
lordship.
Yeah.
3 lordship, that one word was added lordship. The bidder should not be defaulting in paying the banking dues lordship. That default word is lordship in earlier part lordship,
Clause 3.
3 lordship.
The bidder shall have to upload the copy of the
Lord-
solvency certificate.
Lordship.
Should not be defaulting in paying banking dues. It is
Lordship.
not applicable in respect of in its own but
Lordship.
bank statement.
Lordship.
So you have put the GPSS people in a different category.
Lordship, yes, because there is a notification. There is a
Yes,
notification.
this one?
Lordship. It is there, lordship. It's a decision of the
The
cabinet
subject
lordship.
cited above
where-
and as per the decision of the cabinet meeting held on 36, expected to request you.
And basically they are dealing with the food grains lordship. It is not a case that lordship, it is arbitrary exercise by the state authority to lordship favored one person, it is not there lordship. One unit or one GPS not there, it is open for all lordship.
Now they say that GPS would be quoting only for that area.
That was lordship as per the lordship decision of the cabinet lordship. Cabinet says that lordship in the particular district lordship, the preference should be given to the GPSS lordship. As because GPSS are basically deal with the lordship that purpose lordship. That's why lordship.
Why has the cabinet taken such a decision?
Cabinet lordship, that part lordship, I cannot say to the lordship. Otherwise lordship, it is not a case that cabinet has taken a decision to lordship deprive the others.
Well, the cabinet would obviously take a decision on the basis
On
of
the
something.
basis of that, probably it is the National Food Security lordship that scheme lordship. NFSA scheme lordship.
Let me see the NFSA
Lordship.
Food Security Act, and there is a rules also. The preferential
And-
rules, there is a preferential rules, some
Lord-
preferential rules.
Lordship. Otherwise, these tender conditions no way affected the petitioner's lordship. No way debarred him lordship. And 23 numbers participated earlier lordship. And it is the wisdom of the authority lordship. Lordship, that particular
When are you opening the tender?
Tomorrow,
You have submitted,
tomorrow is the last day.
you have submitted your bid or not?
Not yet submitted, my lord. Tomorrow is the
Submit
last
your
day.
bid. We
What is the
consider
last-
later on. You should notice,
So far, my lord,
there is no stay.
so far, my lord, cabinet decision is concerned, my lord, it, my lord, speaks, my lord, accepting preferential treatment, my lord.
You have not challenged the cabinet decision. What to do?
Referring, my lord, there have,
Huh?
preferential treatment, my lord, but not relaxation, my lord.
No, there is a preferential, no, I remember that this NFSA has a particular rule, many rules. In my judgment of 50, above 50, I have
Lordship,
written
that
out there.
it is there also.
Huh?
It is probably there also. That part.
There,
we can
I
discuss.
remember this, how this 136 rupees comes to. Oh, this 136 rupees has come to a particular thing on the basis of the government. These people have means the government of Assam now has taken a particular decision to do it by themselves and by absorbing certain amount to the
Lordship.
itself.
Lordship,
That is the reason why, in order to uplift this cooperative society,
Lordship,
there is a cabinet decision which was put up
Lordship.
in that judgment which I have
Lordship.
already dealt with. You deposit, you submit your tender, we'll see later on. We'll issue notice. Have a look at it, you file your affidavit. Let us see. We'll
Shall not be, my lord, finalized, my lord,
That
Huh?
part.
the tender process.
finalize. When is the finalizing date?
That is not there, my lord, it will be notified later on, my lord. Of this.
Huh?
As my lord mentioned, it will be notified later on.
Technical bid opening, closing date is 17/7, tomorrow. Submit tomorrow, you have to be informed after. Financial bid opening will be later on.
Lordship.
See later on. And what is this, another one, Annexure G?
My lord, similar, my lord, tender, in respect of my lord, other district. my lord,
Kamrup.
such conditions are not, there.
Kamrup, they are not having the same thing.
In other district, my lord, this type of conditions are not there. Only this particular Hosea district. Recently, I got my lord, tender of Bangladesh district from.
Why you are not having the similar conditions?
Lordship, it is individually by the district authority. They have.
No, district authorities
Lordship.
cannot have a different thing. If it is depending upon that,
Otherwise, Lordship, almost similar also.
what is almost similar? This is important. Why you are not having for both? Now, who is running the transportation business?
Lordship, it is Lordship temporary basis that was done, Lordship.
Who is running?
But that part I have no knowledge to the Lordship. It was a district Lordship.
I am one of the, my lord, contractor, my lord, in the last year, my lord.
You are running.
Not, I am one of the, my lord, contractor, my lord.
Are you running?
Lordship, my lord, in some, my lord, GPSs.
Now, an extension basis you are running.
Started, my lord, extension was granted for 1 month, my lord, 1 month for some of the GPSs in favor of me, my lord.
So you are also running.
In some GPSs, my lord, in other,
In
my lord,
some
other
area.
contractor are there.
That is the reason why.
Lordship.
I want to participate, my lord, that is, my lord.
Anyway,
We can participate, Lordship.
you participate.
We can participate.
of
There
this,
is
my
no
lord,
bar. Lordship.
Issue notice, making it returnable. You file your affidavit.
Lordship.
We'll have it on, matter requires early disposal. We'll have it on 5th of August.
Lordship, I'll do.
Notice returnable on 5th of August 2024. Mr. K. Gogoi appears on behalf of respondent numbers 1, 2, and 3 and accepts notice extra copies of the same be served upon him during the course of the day. The petitioner in the instant proceedings have challenged the notice inviting tender dated 8/7/2024 and more particularly clause 7 and 21 on the ground that the same is discriminatory in as much as preferential treatment is being given to the secretary of the GPSS/WCCS, which would affect the petitioner in submitting its tender. This court have duly taken note of that a similar condition was earlier there in the tender dated 15/6/2024, and the petitioner along with another 22 bidders have duly participated. However, the said tender was recalled on account of certain clerical mistakes. This court is not inclined to pass any interim order at this stage. Liberty is given to the petitioner to submit its tender if so advised. It is, however, made clear that the tender shall be subject to the outcome of the writ petition.
Item number 2.
What is this?
Office bearer of the committee.
Huh?
Office bearers of the committee, my lord, whose committee is registered under the Kaziranga National Park. Terms of the 1998 rules.
You have not been impleaded.
No.
You want to be impleaded.
My lord, I have some objection, my lord.
What is the matter, Mr. Bora?
Matter relating to, my lord, I am the settlement holder of the fishery, my lord. And my lord, what happened during the running the mahal in question, my lord? In the meantime, my lord, our two bills are there. One bill, my lord, developed by the forest department. And at that moment, my lord, during the excavator by the forest department, water is coming, but they close the main door of the both the pill, my lord. And they promise us, my lord, please may kindly see page, my lord. In my writ petition, page 25, my lord. Page 25, my lord.
You are a settlement holder of Nodwar Meen Mahal. So the department is now developing two other fisheries.
Right.
Koru Dalpani Bil Mahal and Big Dalpani Bil Mahal.
Right.
And they are constructing some embankment.
my lord.
Where?
Wherein Soru Dolpani Bill, my lord. Soru Dolpani Bill, my lord, there's some construction.
And thereby the fishes are not coming to your,
Water is not coming from Big Dolpani Bill. There is a, my lord, if honorable court permit, what this is a map, my lord. You kindly see there.
Okay.
Dada. This is the map, my lord. All water is coming from the Big Dolpani Bill to my lord, Soru Dolpani Bill, my lord. And my lord, in the moment, at the time of my lord, my lord, there's a cross mark, my lord. This is the point, my lord.
which one?
We both do. Soru Dolpani Bill and Big Dolpani, there's a mention. And during both, my lord,
Dangor Dolpani.
and
Yours is?
both Dangor Dolpani and Soru Dolpani, we are in possession.
No, this Noduar Dolpani is, what is this? Noduar Min Mahal is where?
In Jamuguri, my lord. Two
This is
bills are
different.
there.
This is different.
This is the
No,
Big
your fishery is somewhere else.
Yes, my Big Dolpani and small Soru Dolpani, my lord. And they develop in Soru Dolpani, and water is coming for the Big Dolpani. There is a mention, my lord. And there is a cross mark. First, it is not second. First is first. There is a cross mark.
Where?
There is a red in cross mark. They close the door, my lord, at the time of development, my lord.
Now they have opened it.
Now directed by the DC to open it, but they were prevented me.
Who?
My lord, there is an enclosure, my lord.
They are the encroachers?
Yes, my lord, there is a, or my lord, I am written a complaint is before the DC, and they protect fishing or catch out fees along with my lord,
So
enclosure.
they are the encroachers.
Their name is there, my lord, in my representation before the DC, my lord.
And because of that, the DC removed it.
The order was given, but due to their my lord, the DC cannot, my lord,
DC cannot.
do this, my lord, to open the shelter.
So don't you think that they should be made parties?
No, cannot,
Yes.
my lord. Because of that, he has no,
Then I can issue a writ upon them not to interfere.
my lord.
Don't you think that?
My lord, there is no Lucas tender, my lord.
Understood.
My lord.
But it is because of them you are facing the difficulties.
My lord, DC has not to do the work, my lord. Because of that, they are all,
DC will work, don't worry.
my lord,
DC will work.
my lord.
But they are the persons who are causing the problem to the DC. Don't you think that?
My lord, they have no right, my lord.
Whatever right is, they have no right to file a writ petition. No quarrel. But don't you have a right to direct the DC? And along with them, these people also should not interfere.
Can be, my lord.
If they are made parties, wouldn't that be in your favor? Because you have submitted a representation saying that these are the people who are disturbing us.
As an enclosure, my lord.
So,
My lord, now,
in,
my
in
lord,
your writ
my
petition,
lord,
they,
main problem is that, my lord, development is done by the forest department, and there the NGO, there's the NGO, and member divisional forest officer and forester is the member secretary.
so
But
they, whether
have
they
no-
have any,
no-
whether they have any business out there to disturb or not, can this court not decide in this? Because otherwise, don't you have tomorrow to file another writ petition if they keep on disturbing?
My pair is only, my lord, to open the door, my lord. This is my pair.
But they want the closing the door.
They don't initially they doing the
So
my
what
lord,
do they want? They want the closing the door or not?
the closing door they did not. The closing by the other assurance by the forest department closing that. Now they say that you don't open, my lord. This is
They are the people who are obstructing it.
they are obstructing, but
So
forest
you will
because
see
of the
they
they are
will
the
keep made
NGO,
parties.
but the divisional forest officer is the my lord, member secretary.
Chalo.
He has no Lucas, my lord, because no NOC is there. The
Who?
disorder is forest department stated that, my lord. This is the letter, my lord. To
Who
open
is
it
Sri
immediately.
Dal Mohan Chetri,
Yes.
Kesav Roth,
He is the
Vishnu Karka,
the-
Nordwar Basnet? Who are they?
here the enforcer, my lord, in my petition, my lord, if honorable court permit me, my lord.
Wait,
Please.
wait, wait.
Is in my reply, my lord. I have annexed it, my lord. Page 33, my lord. Page 33, my lord. They are the enforcer, my lord, and now they are coming as a pleading as a party, my lord. Saying for him.
Mr. Sharma, what is this? Who are you?
I am, my lord, the petition number one, applicant number one is the president of the Eco Development Committee, my lord, which is registered under the Kaziranga National Park, under the 1998 rules. I have annexed the rules, my lord. You also kindly come to the additional review was asked to be filed by the court, my lord, and we filed it in Annexure 2, page 98 rules,
Under?
page 32.
32, yes.
Certificate is annexed with the
Make the following rules for active participation and involvement of local for regeneration, maintenance and protection of the degraded forest and plantation. Yes, then
under rule 7, sub-rule 7 of the said rules, the Eco Development Society committee was formed by the public under the guidance of the Kaziranga National Park, Director of Kaziranga
you are that committee.
Committee. I am the my lord, president. Third and vice president, they are here. And it is a serious role to play, my lord. If you also go through the
So this is a committee constituted under a rules. If it is a committee constituted under the rules, why the committee is not before the court?
because there was urgency in filing the application. Otherwise, the amendment is big amendment, not small, smaller.
Whatever may be. Now, why the urgency has gone for a 6, taking into account you filed this application when? When you filed the application in 2019, June 2024.
Yes.
Did you get any order?
My lord, what happened here, let me explain. In 2015-16, my lord, the
No. If it is a committee, why you are not coming? And where is that committee? If the committee is there under Rule 7,
Yes.
it's a committee constituted under Rule 3.
Yes.
It's a Rule 3 committee.
Yes.
If it is a Rule 3 committee, it will have it will have its entity.
yes, entity,
If the entity is there, why are other persons coming in? President, the other secretaries. Huh?
what is my lord?
They have all this meeting of quorum and all these things.
Yes.
What is this? The committee has to come. Nobody else. You are nobody. No president.
Tomorrow we'll file.
Huh?
We'll file application.
Because we reject this application. Come up and give you liberty for the committee to file application. The committee has to come, not this. You can't have this 6, 7, and 8, all this. If the committee wants to come, well, let the committee come. Very well. Because the committee has, because you individually may not have any right.
Yes, sir.
The committee has a right.
Committee is also right, my lord, individuals, because there are some kind.
Individual, if you are right, you have to show that you stay there. You are affected out there. All these things.
That will just hear with you for 5 minutes.
I am hearing you for 5 minutes. Tell me.
There are some kind, see.
It is a registered committee. Why the committee is not before the court?
There are some kind, see. The role of the committee, my lord. Page 100 of the edition.
Huh?
Page 100.
That is why I was looking into it. Why this
10.
110?
So this man, is the because that's what I wanted to say. We will fight by tomorrow. 110, my lord.
No. We'll have the committee. Come up with a committee. Nothing on, not on this basis.
Beat officer and forester is the member secretary, madam.
Huh?
Beat officer and
No,
forester is the member, page 34, madam. The beat officer, comma, or the forester as case may be
Page
the member secretary,
34.
34.
Yes,
forester,
where?
one of the member is transferred, my lord.
But madam, the
The
beat
beat
officer
officer or the forester, as the case may be,
as
as
a
the
member
members shall
secretary.
convene the meeting of the executive at least once in every month and once in every 6 months a year. Of the beneficiaries for the executive shall be elected every year, so and so.
A divisional
right
forest
you have?
officer directed to open the seal. I am given another matter. It is
What?
this letter,
It's
madam.
constructed by the Kaziranga National Park, my
The
lord.
divisional forest officer so requested to
May I,
DC
my
to
lord,
open the
one
cell
thing?
top, my lord.
Kaziranga
But they have
National-
no, my lord. They are not
Kaziranga National
coming.
The
Park is
composition of the
constructed
executive committee will be the Gaon elected representatives, concerned beat officer, member of the executive council, constitution of so and so, so and so, so and so.
with entire village.
The committee has to come. nothing business. This is an application filed IA 1907 of 2004. This is an application filed by the applicants claiming to be the president of the Eco Development Council. What is this Eco Development Council?
The NGO to be formed under the public participation in management of forest.
Where is that formation? Eco Development Council.
Right? Will also while come to the application.
Huh?
My application, I will next A. Page 15 of the application, madam.
Page 15 is some Eco Development Committee.
Committee.
And what is this Eco Development Council?
It's wrong with that. It is committee throughout.
But this type of application cannot be. If you are registered, you are certificate of the Eco Development Committee. So this committee has to come. Eco Development. Tiwaripal. Eco Development Committee of Eastern so and so Bokakhat under Northern is hereby registered under so and so. So that will come. Who is this Eco Development Council?
Council, somewhere it will in council.
No. There is an application filed by the applicants claiming to be the president of Eco Development Council. Full stop. However, it is noticed that the however, for perusal of Annexure 1, it is noticed that it is the name of the registered body is Tiwaripal Eco Development Committee,
Just for may I intervene?
registered under the provisions of Rule 7, Roman 7 of Assam People Joint Bracket People's Participation Bracket Close Forest Management Rules 1998. Full stop. This court has also perused the additional affidavit wherein the rules of 1998 has been enclosed. From a perusal of the said rules of 1998, it reveals that a committee is to be constituted in terms with Rule 3, and the constituent members of the said committee as to how the committee is to be constituted and how the committee is to be constituted is stipulated in Rule 7. Full stop. Taking into account that the applicants herein have referred themselves to be members or president or members of some of accounts of an Eco Development Council, which has no existence. The instant application is bereft of any merit for which the same stands dismissed. Before parting with the records, this court, however, observes that there shall not be a bar for the Tiwaripal Eco Development Committee, so constituted under the rules of 1998, to file appropriate application if so advised.
Now,
I stand this way.
hello, other part. Just
Huh?
one thing I want. other
Yes.
part is not- just one thing I want to point out. On the 10 of the 87.
Huh?
On the 10. On the 10, madam. 87.
110, I've looked into it.
Just below.
That is that Bharat Das,
On the
name
10.
of the contractor.
No.
110,
No, 110 of the my ABD bit. 87.
completion certificate.
Below, down below.
Yes,
12 Setri.
yes.
Tiwaripal Eco Development Committee.
So it has to be Eco Development Committee. What is you have mentioned is Eco Development Council. Can't be. File a proper application and let the committee come. Nobody other. How can the president, anybody else can come? if it is a committee which is constituted under the rules, it has the existence. They can very well come. I'm giving you the liberty. Suppose.
From the regional forest. Much. Well, main case may be listed.
What?
Main case, made petition may be listed.
Main case is not before the court today.
Much.
What is this big file again? You always come up with big files. What is this?
Issue is very small otherwise.
What?
May I submit one thing before my friend submit? Lord?
Huh?
In this case, earlier I was engaged for the workman, but I am being disengaged.
You have?
I was appearing for the workman, respondent number one, union representing the workman, but I am being disengaged and it will taken back.
This is against the labor code.
It's a labor
Labor
court's
code.
order. I'm challenging it on a particular point of law that the procedure that has been otherwise governed by the Supreme Court has not been followed in this manner.
What is that?
The issue is once the management in a labor court reference, once the labor court challenges or issues a preliminary objection on the fairness of the domestic proceeding,
It is for them to do it.
it is for the labor court to first take up that issue of fairness of the domestic inquiry.
Ludbut Singh.
Ludbut Singh followed by various other judgments. Shambhunath Goyal and another. First knows about that. So ultimately, once the labor court comes to a finding that if the domestic proceedings is vitiated, is not fair, then an opportunity to adduce evidence on merits is to be given, provided that in the written statement, the management has taken that ground. That we want to raise an issue on a preliminary objection on the point of the fairness of the domestic inquiry. In the event, the labor court held that the domestic inquiry is not fair, then an opportunity to adduce evidence and decide the matter on merits should be provided to the management. That is the law. What happened in this case is, though the preliminary point was framed, though an argument took place on the aspect of the domestic and the fairness of domestic inquiry, finally, the labor court, while passing the award, proceeded even beyond that and passed the final award, setting aside, passing an award, setting aside the very dismissal order of the domestic proceeding.
I didn't get you.
Yes, I'm just placing it in a proper perspective. What has happened here?
On 2/1/2017 for hearing on the preliminary issue, it was fixed
Yes,
as to whether the domestic inquiry was free.
it's fair.
So prior to that, you give some evidence.
Prior,
Normally, some evidence is given as regards with that particular inquiry officer.
yes, only that
That evidence is given. Thereafter, did you ask for giving evidence?
that opportunity was not given to us. In our WS, in our written statement, the categorical point that we had taken was, please raise that issue of that preliminary point to decide on the aspect of fairness of domestic inquiry. And if not, then the management should be given the opportunity to adduce further evidence to prove its case on merits.
Hmm.
The preliminary issue was framed, arguments took place, the inquiry officer's evidence was taken only on that aspect of the fairness of domestic inquiry.
And decided the entire thing.
Entire matter and set aside the very proceedings as well as past orders whereby the dismissals were also interfered with.
And the matter has been pending since then.
Yes, Lord. Sir.
Oh.
So probably my friend will also not be objecting to the proposition of
But
law.
I do not have any
I
locus,
do-
my lord, because file is taken back from me.
We will consider that you are not there itself.
My lord. Only because of that I am before your lordship.
There is always a
convey it.
saying, turning a blind eye, deaf ear. Here it is a case of turning a blind eye upon you. I won't look at you. Let me see the records.
Otherwise, that part is in the obvious, my lord. Admitted.
Will also come to our WS filed by the management. On 2/11/2016, the
Oh,
management had filed its written statement, wherein at paragraph 26 is the
Who is Ananta Goswami?
He is
He
an
was
independent
inquiry
advocate, the inquiry officer.
Then after giving it of Ananta Goswami, then why did you ask for further time for giving other evidence?
On only, I think only on the point of proving the domestic inquiry will be fair. Because the preliminary issue that was framed for argument was only on an aspect of fairness of domestic inquiry.
Who is MW2? What is MW2's evidence?
One manager was examined. One manager was examined.
I fairly submit this record was given to me only in the morning, this lower court record.
You always come up with all this type. Last time also you have
I
come
am
up with a
just submitting
similar
the
thing.
facts,
That
as-
arbitration appeal also
but
you
that
have come
was-
up
that
with
was
all these
argued and
things.
ultimately disposed of by your lordships.
So this also needs to go as soon as possible. Huh?
Difficulty is that
Uh,
I am a successor of all these cases by inheritance.
Very good.
The morning I was given this entire lower court record, so bit of a difficulty also on those aspects.
Here you get it. See, 26/7/2017, parties are represented seeing the petition number so and so filed by workman side praying for argument on preliminary issue. Third side's prayer is allowed, fix 3/8/2017 for argument on preliminary issue. 3/8/2017, parties are represented, hard arguments advanced by the learned counsel for the parties, award is reserved, award passed.
Award pass, yes, sir.
So there you have the case. So it was for preliminary issue, not for others.
That is my instruction.
So on this, so we finish it off.
Admittedly,
We remand it
from
to them.
Delhi Lot and General Mills, but I cannot submit that is there.
May I just place the judgment which sums up all the
Not
earlier
necessary. Judgments are there for Supreme Court. Yes, okay. Why should I make this thing long? Yes.
This Karnataka State
The
Transport
instant
Corporation judgment.
petition has been filed. Heard Mr. A. Sharma, the learned counsel, appearing on behalf of the petitioner. To stop. You appear?
No, Lord. I was
None appears on behalf of the respondent on call. Mr. appears for the government? No government. Presiding officer,
looks
labor court. How could you make the presiding officer, labor court
I think
a
it was
party?
mistake, should not be by the party.
And appears for the respondent number 1? Who stop? Mr. So-and-so, appearing on behalf of the government, submits that the respondent, that the petitioner ought not to have impleaded the presiding officer of the labor court. He submitted that the Supreme Court had, in various judgments, deprecated this conduct. Full stop. Of arraying the presiding officers who passes judicial orders. This court have also duly taken note of that it is well settled that it is no longer res intriga that the presiding officer of the labor court who has passed a judicial order could not have been made a party. And as such, while reprimanding the petitioner for impleading the presiding officer labor court, strikes out the name of the respondent number 2. Next. The instant writ petition has been filed challenging the award dated 17/8/2017 passed by the Learned Labour Court Assam in reference case number 13/2003, whereby the Learned Labour Court, by its award, held that the preliminary inquiry which was held was perverse and was not based on proper appreciation of the materials on record and the materials before appreciation of the materials on record. In doing so, the Learned Labour Court had also held that the workman was dismissed without reasonable ground and as such directed that a workman be reinstated with full back wages. This court have duly taken note of the ground on which the limited ground on which the writ petition has been filed. Mr. A. Sharma, the Learned Counsel appearing on behalf of the petitioner, submits that the matter which was pending before the Learned Labour Court was on the decision as regards the fairness of the preliminary fairness of the domestic inquiry, which was framed as a preliminary issue, and not for the decision on merits. Referring to the written statement filed by the management,
Paragraph 26.
and more particularly at paragraph number 26, the Learned Counsel submitted that it was the specific stand of the management that the fairness of the disciplinary domestic inquiry be taken up as a preliminary issue, and in the circumstance the preliminary issue is decided against the management may be granted an opportunity to contest the reference case. This court has also perused the entire order sheet, and from the order sheet it reveals more particularly the order dated 26/7/2017 that the case was fixed for hearing on the preliminary issue, and on 3/8/2017 the judgment was reserved. Under such circumstances, the Learned Labour Court would have at best decided on the fairness of the preliminary inquiry, and thereafter ought to have granted an opportunity to the management, the petition hearing, the petition, to contest the reference case, which however was not done by the impugned award dated so and so. Accordingly, this court interferes with the award dated 17/8/2017 to the extent of deciding the entire reference case, being reference case number 13/2013. This court, however, 2003. This court, however, does not interfere with the decision of the Learned Labour Court in deciding that the domestic inquiry was not fair, or more particularly, the issue number 1. However, interferes with the issue number 2 and directs the Learned Labour Court to decide the reference case on merits by giving due opportunity to both the parties to adduce evidence if so desired. This court remands the instant remands the instant this court. Now, with the above observations and directions, this court directs the registry of this court to forthwith transmit the records of the reference case number 13/2003 to the learned presiding officer, Labour Court, Guwahati, so that the said court is in a position to take up the matter at the earliest. With the above, the instant petition stands disposed. Were you paying this 17B?
Yes, sir.
Pustup. It is further observed that taking into account that on a technical aspect, this court has interfered, the management shall continue to pay the last drawn wages which the management have been paying during the pendency of the instant proceedings till the disposal of the reference case.
Obliged, Lord.
The party is taking into account that the management side is appeared. The party is directed to appear before the learned Labour Court on 19th of August.
Obliged, Lord.
LCR return. আগতে দিছো ন registry. Itu forthwith return like special messenger সেইখিনি লাইনটো লগাই কেবিয়েট দিছা কেবিয়েট নাই what কেবিয়েট তো আগতে আছে কেবিয়েট হৈ গ'ল কেবিয়েটৰ কাম আগতে কেবিয়েট দিছা আছে Yes, Mr. Sharma, what is this?
The petition is filed challenging electricity bills.
Huh?
Electricity bills. There is a small background to it.
You are challenging electricity bills?
Yes, in fact,
Why?
the payment of the bill, Your Lordship, along with a direction from this honorable court that a new meter be installed at the premises of the respondent, of the petition. There's a background to it, Your Lordship. If Your Lordship can kindly take up the affidavit in reply or the additional affidavit, the pattern of the electricity.
Where is the PDCL?
Was here, Your Lordship.
Huh?
When was here, Mr. B. Chaudhary appearing for the APDC, was here.
These people are not here. PDCL and
That what
you,
happens, Lordship? Just the background.
you are enjoying a stay.
I'm enjoying this.
Fantastic, enjoy it.
I'm grateful.
Okay. None appears on behalf of the APDCL on call. So under such circumstances, the matter stands adjourned to be listed immediately after the puja vacations. Interim order passed earlier shall continue. You want a date? On 12th of November 2000, let us have it on a Children's Day, 14th of November 2024. Interim order passed earlier shall continue till then.
Better, my lord, today we have received a copy of the affidavit filed by the PWD investors. Matter relates to, my lord, that they demand us to provide the forest clearance certificate, my lord, which was not a part of the condition.
Mr. Counsel, do you want to do the matter or not?
I don't know.
Okay. At the request of the learned counsel for the petitioner, matters adjourns to be listed after 4 weeks. You're enjoying a stay?
Demand of forest fire clearance certificate, my lord, there is no stay order, my lord.
Regarding deduction of forest royalty from the bills.
This is the issue.
You're not taking the money?
Well, so far as
They are not
forest
releasing
royalty
the
part
money,
is concerned, that is with us. Rest of the bill amount, yes, what's up?
The amount I have,
Only the
paid,
forest
my lord,
royalty
the forest royalty amount, they are not paying us, my lord.
So you have no urgency?
We have the urgency, my lord, but we have to finally reply, my lord. So sort it.
Okay, Mr. So-and-so appearing on behalf of the petitioner seeks some time for filing a reply against the affidavit in opposition. This court also duly takes note of that the affidavit in opposition was filed by the forest department,
No, by the.
by the PWD is yet to come on record. Accordingly, list the matter again on, you want a date? No date. No date. List the matter again on 4th of November 2024. In the meantime, the reply will be filed. 4th of December?
August,
No, November. Bench 4. If you have no urgency, don't do it.
4th of November.
4th of November. Yes.
NIT was challenged at page 120. I think it has spent its force by now. That was the submission on the last opinion also, I think, for that time.
NIT challenge.
Page 120. Regarding that transportation of DPSs.
Transportation of what?
Food trains, lots of page 120.
Committee based on
NFS
are lifting.
Period of work was 23, 24 minus.
Then
As well, this may have become infrastructure because my lord, it was 423-24, my lord.
infractions. Mr. A. Sharma, the learned counsel appearing on behalf of the petitioner submits that the writ petition has become infructuous in view of the fact that the tender in question was for the year 2023-24, and the time has already elapsed. Consequently, the instant petition stands disposed of as infructuous. Maintain order stands strictly.
Instant restriction has been filed challenging the notice of the county municipal corporation. But they have directed me to stop my bed and breakfast.
Bread and breakfast?
And residential.
Yes, Mr. Bora, what is this? In Tamil Nadu? What is this Tamil Nadu doing?
Patrapuri Bond. It's a residential complex.
What were you running? Bread and breakfast.
Facility as per the Incredible India scheme.
What scheme?
Incredible India. scheme.
Incredible India scheme. You are running a bread and breakfast facility. Now this bread and breakfast facility has been stopped by GMC. Why?
Saying that I do not possess the required trade license.
Fantastic.
Now, in their portal, there's a trade license for homestay.
Hmm.
Which I procured for abandoned property. But under the scheme, also there are judgments to show that it's not a for which purpose. A trade license. Needless to say,
You don't need money?
in the portal also, needless to say, man, in the portal also, they don't have the option of bed and breakfast.
What is this trade license business?
I don't,
This is under 183? Isn't
180 of the GNC. 180 of the GNC.
180? What is this trade license? It's a professional tax?
Agreed, man. Agreed. But then also, but there are two folds, man. One, I only require a certificate.
They've
for-
closed it. You need a trade license. That is the reason why.
And the trade license which I had also as abandoned property.
Is that the reason why?
Trade license, he wants the trade license he has taken. Say that trade license has been taken in the homestay as an abandoned person. In fact, he needs to take a trade license. There is a bylaw also that he falls under the bylaw, he needs to take a trade license.
Trade license. You are going to give it?
Yes,
You give it to him. He apply. Finish.
So, man, that is my second and third prayer, man.
So he will apply. You
He will
give
apply
it
trade
within
license
15
only.
days.
He will
You
apply
see, trade license is, that is why I asked you. A trade license is what? A trade license is the way by which you are going to earn a revenue.
Revenue.
It's like a professional tax, isn't that? 180 GMC accounts are. So you let him apply. You
It
give
will
it within 15 days.
if it is not in the portal, because this is a new concept. This is a new concept. It's not in the portal, you have to make it manually. Because this is bread and butter as per the.
The only reason you are not giving him because of a trade
Trade
license.
But
Let him
if
apply
losses
and
starts
give
to
it
pay
to
the
him. You give it.
10, 15, the impune order, my lord.
Huh?
impugn order.
Wait. Where is trade license?
One
Business
second,
180. Yes, license. To be every person who exercises or carries in the city either by himself or by any of the profession, trades or callings indicated in the fourth schedule shall be annually take out a license before the first day of April each year, of which 1 month of a month so and so. That the commissioner may remit or refund or whether at any time grant a license for any previous year for which no license have been paid and so and so. Power to call for a list of persons. So liability and class how to hear. This is, you see, I remember taking into account that this you consider it to be a tax, not a fee. Under such circumstances, it's a tax. So it's something like he wants a registration. Why you are not giving him the registration? Let's see the impugn order. The end of the day, GMC wants money.
115.
Let GMC get the money. And then better roads, better facilities for us. Okay. Whereas an inspection was carried out at your premises by the Office of the Health and Environment, and in the time it is observed that you were running the trade of homestay with an invalid trade license in a residential apartment. Failed to submit the NOC from the residents of the Ideal Hill, your housing complex building. Third, the power conferred under you have. So what is this power being exercised? Not under 180. This power is exercised under what?
Lordship, before, at the top of the notice, and under section 180 also is there.
180 is okay. That is for trade license. 378 is?
70 is different, it should have not been.
No, you are asking that he requires to take the permission from the other people. That is why I am asking you.
He says that the order says there is no NOC from the housing complex
Yes.
society. There is a multi-story building. There is a society or something like that association. There is no NOC from that particular association. To run a bed and breakfast from a particular flat.
Signature, conditions, duration, suspension, revocation, etc. of licenses and written permissions. Now, on what basis are you asking that you require their NOC from the residents of the other places? What is your basis to ask for that? There has to be a basis.
There is a complaint, my lord.
Huh?
There is a complaint.
Somebody complains that do you have the
Public
power?
complaint.
But do you have the power? And did you inform him that there is a complaint?
That may not be, but there is a
On
complaint.
that ground only, we let us settle.
But they have to register.
He
it.
says everything yes.
But they have to.
I can present my case, man, to refute everything what he is saying. I can present my case to refute whatever he is saying.
But
Or
you have to
NOC,
take it.
everything.
No, therefore, no, I'm asking you, okay, trade license he will apply.
You will apply.
What type of trade license do you require?
Homestay, it will be a homestay.
He has a homestay.
Homestay here, he says he has taken it. He is not entitled to take it, but he has taken it on a one-hand question.
No.
You have to take a trade license and pay for the fees for that.
The trade license for what?
Homestay at least.
So already he has a trade license.
No, he has taken it, but it has expired. It has expired. He has taken it as a abandoned question. Now he says that because the portal doesn't have a bed and breakfast, he doesn't want to take a trade license because it is not required to take a trade license.
That was my case. That was my case. But today, if he is saying that
No, because you see, it may not only be trade, professions and callings. So all are there. Callings is too big. Professions, all type of professions are there.
the learned friend is saying that for the bread and breakfast facility also, if they don't have a trade license option, I have to opt for the homestay option. Then they have to allow me to run based on that homestay license, which I will apply in the portal. And the moment I apply that, I pay the fee. Within 10 or 15 minutes, I get the license.
You take that 15 minutes. Well,
let him take it, but he's running a franchise.
You give it. I see there was one matter where Mr. Das was appearing. In that matter, where there was a specific direction not to allow the GMC to do all these things, also you have allowed the GMC, and the GMC have issued the trade license. And later on, when I catch hold of them, then they say, oh, it is automatic. Whenever you apply through the portal, you do within 10
No,
minutes
that-
you get it.
No, that thing is that this is regarding homestay. Other is the regard that I can recall, my lord, that is regarding a building where it is not even a commercial, it is running a hotel. That is something different.
He wanted to do it as guest house.
Guest house. Guest house is something.
When I stop him from doing the hotel, he says guest house.
Guest house. Now it is the
So
guest
now here he wants a homestay.
homestay. And here is the residential building, my lord. Multi-story residential. One on his own name, other flat is on rent. Two flats.
Even in the same deed, everywhere, no objection is granted. Then by the builder.
No, but I don't understand wherever and whereas you have failed to submit the NOC. What NOC is required?
NOC here, it means that the NOC from the society. Society has not
No,
given
no,
NOC.
what is your power?
But that is not there. NOC.
If you don't have that power, how can you say that and whereas?
NOC
We have
is
to
from the-
interfere with
There is
this.
a no objection certificate from the society. It is there from the residents
No,
of
if
the.
the society can very well do whatever they,
Yes.
the society, and if the society have given a complaint, then you have to enforce, give it to him. You cannot do that.
That happens.
You are going to apply and do it. We interfere with this order,
But specifying that he should apply.
subject to he applying for trade license and getting it and running
Getting
it with a trade license.
In the form of a homestay, not, but since he will get only the homestay in the portal, or if not, or bed and breakfast is not, bed and breakfast is not, the scheme has not come in Guwahati. It is the scheme which he is highlighting is from Delhi.
The
From
moment my
Delhi?
lord,
Delhi, that scheme is for Delhi.
I give it as an example. Delhi statute is given as an example which says that no license is required from such authorities. The moment I have the certificate from the Ministry of Tourism. And if my lord specifies in that order that I have to procure a trade license of homestay, it will secure me, my lord.
Yes.
Then we are from homestay. And let me come back, 2 o'clock. I have so many affidavits filed by you.
But on 31st of January, the tourism had expired. So I applied for it. Status was given for an affidavit, and finally, when the certificate came in the month of June, again that was also placed on the.
Hmm.
Now it's- Again, when the certificate came, that was also placed on record once again. It was in the month of June, valid for another 2 years. So
What is the NIDHI? National
That is
Integrated
the-
Database for Hospitals.
termed as meeting.
This is registration from the what do you call?
Or you will see page 137 and 130.
Now, Mr. Bora, what is the trade license he has to take?
He has to take trade license under section 180 as well as under By law,
No, understood. What trade license?
you have to take it as homestay.
You have it as homestay in the schedule.
In the port schedule, there is it is homestay. It is there in the portal, but it is in the bed and basket is not there in the schedule. The bed and basket is a new concept.
But what do you say? Indicated in the fourth schedule.
Lordship will
If it
continue
is
up to
not indicated in the fourth schedule, then what happens?
page 185 of the book. 185.
PL number 12.
Hotel keeper, boarding house keeper, lodging house keeper, manufacturer, retail trader, or shopkeeper for not less than 10,000 rupees income.
3,000?
Minor, it will be 1,500 actually. For third column. So third column will be 1,500.
This is old one. I
This is
think.
old one. Then in the 1st June 2009, there is a revised. Is revised there. It is
Actually
old.
in the port.
Now, where is the homestay? Homestay is where?
An example, if your lordship peruses my previous license, trade
Yes,
license
109.
109
Page number 109, it is here. What it as a homestay.
Page 109 of what?
of equity, of the equity. The second line, homestay having up to 15 beds, non-air.
So you had this? Then how did you issue this?
Exactly. As per fourth schedule, I have it.
Then, therefore, the question of issuance of this communication, where is the impune communication?
Page 115.
Page
115.
Okay.
115. 115, why is it required then? It has to be set aside. This license was valid till when?
So still 31st of March 2024, my lord. And after that also, I have acquired the latest one of it.
Is there? Where?
It is not on record.
Got it? Give it to me.
I'm shifting it to my mother's name. That's why I have procured it in my mother's name this time. Of May 2020.
Mother's name?
Mother's,
How will you do it? Mother's name?
I'm shifting my, and for this financial year, I'm shifting it to my mother. The facility, the premises is there.
Premises belongs to whom?
There are two premises.
Son.
Two premises.
Now, how is the mother? How did you get it from your mother then? And if you have got it from your mother, then how can this writ be issued against saying this to be, you have a license?
Sir, after all these incidents took place, after my trade license expired in the month of March 2020. Now I have entered into a rent agreement with my mother. Premises belongs to me, Pranay Budwan. Now I have entered into a rent agreement with my mother. Got the license, trade license also in that. That is during the inter-exam of the inspection. That's why I have not faced it on record. And your lordship directs me to procure a fresh license in my name, me being Pranay Budwan.
You will have to obtain your
Then I'll
fresh
do it.
license.
I'll do it.
Because they have to acquire license, two license for to do different flats. One is on his own name, one is on his rented premises. They are not running
How many premises you have?
two premises.
Here, this notice is in respect of only one flat, flat A, 8A, and C, 1B.
Yes, both are different.
Both are different.
8A.
Both belongs to you.
C1B is rented.
You have
by
rented
me,
it.
Right? If the premise is owned by someone else. And 8A I own.
And this trade license is in respect of that
Of
flat.
that 8A, madam. Because that C1B was quite new. It was so new that,
So you did not have a license for
yes. I was-
8A.
For C1B, I did not, because I took up the rent very recently as to the notice, and I was going to apply for a trade license in the new financial year. That is my explanation in the report. So for that rented premises, I did not have a trade license admitted. And for 8A, I have this trade license, which you're also.
So C1B, you had no trade license. So you were running without a trade license.
Was
So
quite.
the notice is good for that purpose.
Yes. I have to admit.
But
The second
notice
part-
itself is an invalid trade license. There is no trade license on this aspect of the one of the rented premises. He doesn't have the trade license.
So he does not have for one, a C1B. Okay. Yeah. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. S. Bora appearing on behalf of the respondent GMC. The instant writ petition has been filed by the petitioner challenging the notice dated 21/2024, issued by the Commissioner Guwahati Municipal Corporation, whereby the petitioner firm, na?
Property.
Petitioner's proprietorship firm was directed to close down its trade of homestay, which the petitioner was carrying out in flat number -A, -8A, and flat number C-1B, situated at Ideal Hillview Apartments, VIP Road, Patharkuari, within ward number 24 Old, 58 New of the Guwahati Municipal Corporation. The brief facts leading to the filing of the instant writ petition is that the petitioner herein, who is the petitioner? The petitioner number 2
Petitioner number 2 is the property.
herein, who is the proprietor of a firm in the name and style of MS Hillview, which is the petitioner number 1, was running a bed and breakfast establishment in a flat owned by the petitioner number 2, being flat number A-8A, and another flat being, which was rented, being flat number C-1B of in the Ideal Hillview Apartment. Admittedly, the petitioner had a trade license for homestay, inverted comma, trade license for, inverted comma, homestay, comma, having up to 15 beds, bracket, non to N in all caps, air conditioned establishment, bracket close, for flat number A8-8A. However, the petitioner did not have any trade license for running the bed and breakfast establishment for flat number C-1B, which the petitioner had newly rented from its owner. Under such circumstances, the impugned communication was issued on notice was issued on 21/2024. By the Commissioner, Guwahati Municipal Corporation, for closing down the trade carried out by the petitioner in both the flats immediately, failing which the premises would be sealed without any further intimation. The petitioner, being aggrieved, have therefore approached this court by filing the instant writ petition. This court, by an order dated 4/3/2024, had issued notice subsequent thereto. An affidavit has been filed by the Guwahati Municipal Corporation through its joint commissioner, stating inter alia that the bread and breakfast oblique homestay, etc., is a commercial activity for generating income against short-term accommodation facilities along with other services. And as such, trade license under Section 180 of the Guwahati Municipal Corporation Act 1971, for short, the Act of 1971, read with the Guwahati Municipal Corporation bracket regulation, hotel, comma, boarding house, comma, rest house, comma, restaurant, comma, room, comma, residential club and places of public recreation, comma, entertainment or resorts, bracket close. Bylaws 1976 is mandatory, being covered under the definition of lodging houses of as defined in the Act of 1971 as well as in the bylaw of 1976. It was also stated in the said affidavit that certain residents oblique society have objection to the trade of the petitioner are to be required meet, not necessary. It was also stated that the writ petitioner had even violated the bed and breakfast establishment guideline, wherein the maximum bed is fixed at 12 beds, but in trade license obtained against flat number A-8A is shown as 15 beds. In the backdrop of the above pleadings, this court have also taken note of that there are various other additional affidavits being filed, bringing on record various documents on the which should show that the petitioners bread and breakfast establishment have been duly registered under the National Integrated Database of Hospitality Industry. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, submits that the petitioner had a trade license for the flat number A-8A. He further submits that the petitioner, which was valid, 8-8A, which was valid up till 31/3/2024. And under such circumstances, the respondent authorities could not have directed the closing down of flat number A-8A by the impugned notice. He further submits that as regards the flat C-1B, the same was a newly rented premises and the petitioner was taking appropriate steps to obtain the trade license in the financial year in question. He further submits that the petitioner has no objection, is not adverse to obtaining the trade license for running the bed and breakfast establishment. On the other hand, per contra, Mr. S. Bora, the learned counsel, appearing on behalf of the GMC, submits that the bed and breakfast establishment of the petitioner comes within the ambit of the definition lodging house as defined in the Act of 1971 as well as the bylaws of 1976. And as such, it is the requirement of law that the petitioner has to obtain the trade license before carrying out any trade, profession, or calling. He therefore submits that there is no infirmity in the impugned notice insofar as closing down of the flat number C-1B. Replying to the said, rejoining to his earlier arguments, Mr. So-and-so, the learned counsel, appearing on behalf of the petitioner, further submits that the notice dated 21/2024 further stipulates that the petitioner had failed to obtain the NOC from the residents of the Ideal View, Hillview Housing Complex. And that cannot be a reason for the purpose of issuance of the impugned notice, inasmuch as the same would be nothing but a malice in law, for which the impugned notice is required to be interfered with. I've heard the learned counsels appearing on behalf of the parties and have given an anxious consideration to the respective submissions. This court have also taken note of section 180 of the Act of 1971, which stipulates that every person who exercises or carries in the city, either by himself or by an agent or representative, any of the professions, trade, or callings indicated in the fourth schedule shall annually take out a license before the first day of April in each year, or within 1 month of his taking up the profession, trade, or calling. This court have duly perused serial number 12 of the fourth schedule, which includes the profession, which includes the trade of hotel keeper, boarding house keeper, lodging housekeeper, manufacturer, retailer, retail trader, or shopkeeper. This court have also perused the definition of the lodging house as defined in section 344 of the Act of 1971, which stipulates a house in which visitors or other persons are lodged for hire for a night or more, and where there is a community of eating or sleeping accommodation. In the opinion of this court, the bread and breakfast facility would come within the ambit of clause serial number 12 of the fourth schedule, read with section 344 of the Act of 1971. Under such circumstances, it would be the requirement of it would be the mandate of section 180 of the of the Act of 1971 that the petitioners are required to obtain trade license for running the facility, the bread and breakfast establishment. First, Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that the petitioner would duly apply for the license in question. First, license in question. He, however, submits that as there is no column out there in the portal for applying for a license for bread and breakfast establishment, this court made a specific inquiry with Mr. Esbora as to under what heading the petitioner has required to apply for the trade license. Mr. Esbora, upon instruction, submits that the petitioner has to apply the trade license for homestay. Taking into account the above, this court is of the opinion that if the petitioner has to run, he wants to run the bread and breakfast facility, it would be the mandate of law that the petitioner obtains a trade license for homestay in respect to both the flats in question. This court also duly takes note of the stipulations contained in the impugned notice dated 21/2024, wherein it has been mentioned that the petitioner is required to obtain the no objection certificate from the residents of the Hillview apartment. This court finds no reason that nothing could be shown by the GMC department, by the standing council of the GMC department under what power the said stipulation is required to be complied with by the petitioner. Under such circumstances, this court disposes of the incident with petition with an observation that in the circumstance that the petitioner obtains the trade license for homestay in respect to both the flats in question, the petitioner would be able to run the bread and breakfast facility subject to other formalities which is required under law. The respondent authorities, more particularly the GMC, cannot insist upon the no objection certificate from the residents of the Hillview apartments for not permitting the petitioner to run its facility. With the above, the instant petition stands disposed of. Anything else? Why? I'm allowing you to run. After that, what are they going to say? Notice rightly issued. You don't have a license. Yes, what is this?
My lord, in this case, my lord, what happened is that, my lord,
You've come all the way from Manipur for doing something.
my
Yeah.
only case, my lord, I have prepared a representation in this regard because on being apprehensive is that, my lord, was my bid may likely to be rejected on the ground of putting one condition which is appended, my lord, here in the page number 9.
Page
Because-
number?
9. Page
Nine.
number 9. May I read, my lord? This is regarding the petitioner, may I read, my lord? The petitioner has also participated on joint venture in CKC projects limited in the said tender. The bidding in respect of the particular package number so and so
so and so, likely to, likely to be opened by the competent authority shortly. However, qualification criteria is mentioned in the clause number 3 of the document for procurement of works. Some rider were mentioned as terms and conditions mentioned in the footnote, which is been mentioned with follows. Non-performance is decided by the employer shall include all contracts where non-performance was not challenged by the contractor, including through referral to the dispute resolution mechanism and respective contract, and the contracts that were so challenged but where the dispute resolution mechanism court of law has not overturned or stayed the decision of the employer. Contracts that were so challenged but fully settled against the contractor, non-performance shall not include contracts where decision of the employer was overruled by the dispute resolution mechanism. Non-performance must be based on all information on fully settled dispute or litigation. That is, a dispute or litigation that has been resolved in accordance with the dispute resolution mechanism under the respective contract, and where all appeals decisions available to the tenderer have been exhausted, my lord. In this case, my lord, what happened is that, my lord, I was debarred in one case, my lord, only on this portion, my lord, in Excel A4, my lord.
Huh?
In Excel A4, my lord, page 40.
A4.
Page 40, my lord.
Yes.
Only for some portion, my lord. In the Sapira, my lord, since the period of 48 hours notice has already expired, the above contract stands signed it in terms of the clause 62 standard general conditions, and the contract that balance work under the contract will be carried out independently without your participation. Your participation, as well as participation of every member partner in any manner as an individual or a partnership firm JV, is hereby debarred from participation in the tender for executing the balance work, my lord. It's very important, my lord. Executing the balance work, and your security deposit shall be forfeited and performance guarantee shall also be. Because I was debarring only for the balance work, because which I could not complete, my lord, because of the environment problem, my lord. Because I could not take out the, soils, my lord, because of the green tribunal's direction, my lord, which I cannot take out the soils, my lord.
Then what do you want now?
So now my humble submission is that, because my apprehension is that my tender, because this is likely to be evaluated for the technical bit, is likely to be offset because of this conditions, certain conditions. So this is why, my lord, I prefer annexure A5 implementation, my lord. Because tender
Annexure?
A5 is 42. Majorly, my lord. So this may kindly be considered, my lord. That's all, my lord. Okay,
You have submitted a representation.
yes, representative submitted on 15/7, my lord. Because election A5, my lord. Because the tender is likely to be open by technical bit. If it is open, then my matter will become in practice, my lord. Because of the, it is not yet open.
Why are you approaching here?
So, my lord, because there is a pending case here in the arbitration matter. Because of the pendency of this arbitration matter, arbitration case number 49 of 23, my lord, is already pending here. Because of the reason, my lord, I am going to be debarred, my lord. Because here in this case, lordship, in the clause which has been submitted, which has been, I have read out, only debarring the portion of the remaining work, not for entire things, my lord. Here, after that, my lord, I have received so many works,
No,
my lord.
repairing work. You were not, you were terminated.
So I was terminated, my lord, only for the first portion of the remaining work, not for the entire things. But now, after that, my lord, I have received so many, contract works, my lord, A3 series, my lord. Here, my lord, in the earlier occasion also, my lord, because I was debarring only on this ground, my lord, on the putting certain conditions, my lord. So only my apprehension is that, my lord, if it is to be debarred by virtue of this pendency of this.
Tell me one thing, Bhartiya Infra Projects Limited
Yes, sir.
is a company registered where?
Rest are here in court.
Why haven't you put that registered office here? Why are you putting the other addresses?
My lord, because one is registered and another because joint venture because
Joint venture is with whom?
with the
JKC and BIPL. What is BIPL?
BIPL is here, man. BIPL is
Where?
here in the page number 4, man.
Huh?
Page number 4, man. You can see page number 4. But
Page
here,
number
Infra Project Limited represented by its director, Rameshwar, Well Arcade, Pibarua Road, Ulubari.
Oh, no.
Page number 4, man.
You are saying that having its office, 1 and 2 is having its office. Show me where is it that it has its office? Show me.
JB, my lord, because authorization letter is there, my lord.
Show me.
Authorization letter may kindly see, my lord. Authorization letter, election.
JKC Projects Limited.
Yes, ma'am.
What is that JKC?
TKC.
Has its head office and corporate office at Hyderabad.
I know.
Then
Now, he has been authorized.
Then show me where it is that why this court should entertain at all this petition.
No, my lord.
The tender is that out there in Manipur. Why should this court entertain?
So my lord, my humble submission is that my lord, because of this particular apprehension, my lord, I prefer this representation that may kindly be disposed of. That much of the F5. The next F5 is the representation preferred by me, my lord, because since I
You have submitted the tender.
yeah, I've already submitted my tender, my lord. I've already submitted. But the only thing is that because of that condition, my lord, I'm just apprehension is that my tender is going to be rejected because of the pollution in the technical evaluation, my lord. The technical evaluation is not yet done, my lord. Only before that, my lord, this representation may kindly be considered, my lord.
So you knew about it. Where is the tender conditions?
My lord, I have read out one, just now one.
Why haven't you enclosed?
Because entire things, my lord, I have enclosed, my lord.
Where?
Please, my lord, may kindly see.
Page?
Yes. Yes, 29. 29. Performance matter. This there matter. Yes, 29 matter. This is the condition matter. Then performance is decided by the employer shall include all contracts where non-performance was not challenged by the contractor, including through referral to the dispute resolution mechanism under the respect.
But you have already challenged it in the arbitral proceedings. So
Because of the arbitration, my lord, there is no stay, my lord. There is no stay because of the reason, because my humble
You
submission
see,
is already.
when there is a challenge you have already made, you see, non-performance as decided by the employer shall include contracts where non-performance was not challenged by the contractor, including through referral to the disputes under the contract. So you have already challenged.
I've challenged, but things are lost because here the condition is that, my lord, if it is not stayed and overturned, because.
No, that is B, not A. That is B.
Yes, ma'am.
The B that were not contracts that were so challenged, but where the dispute resolution decision had not overturned or stayed the decision. That is B. And these are all N.
N.
And contracts that were so challenged but fully settled against the contractor. This is C.
Yes, ma'am.
So non-performance shall include contracts where decision of the employer was overruled by the dispute resolution mechanism. Non-performance must be based on performance influence so and so. Non-performance shall not include contracts where the decision of the employer was overruled by the dispute resolution. Non-performance must be based on all information on fully settled disputes or litigation that have been resolved in accordance with the dispute resolution under the respective contracts and where all appeal instances available to them has been exhausted. Meaning, so
my lord,
you approach this court or both High Court of Manipur whenever you are disqualified.
my lord,
How do you want this court now to say
my lord,
that don't disqualify him? Let the tender committee decide this.
yes, my lord. It is, my lord, before this is, my lord, my representation that might kindly be considered, my lord. Please, my lord.
Why?
Because that, because if.
Why should your representation will be there? Why is it required? They will consider it. When did you give it?
Because I prefer on
You gave it on 13/7. They will consider it.
Yes.
Have they? Their stage of not considering it has not arisen till now.
that my lord.
No.
And I did
nothing.
like kindly be better, my lord, so that my lord. They didn't consider, my lord, what is the harm?
Withdraw and file it. Whenever if you agree, file it. But I think you will come within the ambit of A. There's no problem with that.
My lord, because my apprehension is that on the previous occasion, there was a same contract, my lord, similarly. But I was debarred only on this condition.
So if you are debarred, then challenge it.
Because
You challenge it immediately. I'm here sitting out here.
That tender
Again,
was offered, my lord.
I'm again sitting. I give you unlisted permission. Don't worry.
Yes, my
Didn't
lord.
I give you?
No,
You
it's,
don't
my
have a
lord,
case
only
now.
humble submission is that, my lord.
Sorry.
This representation that may be considered that was only, my lord.
Absolutely no.
The condition, my lord. Otherwise, no, my humble submission is that, my lord, it's likely to be rejected, my lord.
Mr. Counsel, let me tell you one thing. I am a person who never passes an order for consideration of representation. It's too bad for this. I would either direct, take it or don't take it. There is no consideration of representation. Representation that is for them to consider or not to consider. You have a right, you get it. You don't have a right, you don't get it. Representation consideration is not.
Otherwise, no, because
You better withdraw and say that if you are aggrieved by any action, you are at liberty to again appraise.
that can be that the thing is that I am.
Better.
I'm apprehension is the Malord.
Huh?
Yes, that in case if it is considered before the taking action, because then I will be debarred, my lord, then my evaluation may not be done, my lord.
How can I direct this order?
No, I'm not, I'm saying only just to consider my representation. my lord,
Absolutely no.
to
No,
respond with me, my lord.
don't treat this court as a post office.
No, no, not that, my lord. I'm just, my humble submission is that otherwise, lord, sir,
What?
I will be
Dismiss?
debarred.
Dismiss, withdraw with liberty, which one?
Maybe given liberty to approach.
Ah, yes, better.
After approaching.
Mr. So-and-so, the learned counsel, senior counsel, heard Mr. So-and-so, the learned senior counsel, assisted by so-and-so. And Ms. A. Gayan, the learned counsel, appearing on behalf of the Union of India. Full stop. The learned senior counsel, upon instruction, submits that as the representation dated 13/7/2024 is presently pending before the authorities, he would not like to press the instant petition. Full stop. However, he however observes, he submits that in the circumstance that the case of the petitioner is, however, submits that the case of the petitioner is not being considered on the basis of the representation, then the petitioner may be given the liberty to again approach. So, taking into account the above, the instant petition stands closed on withdrawal. However, it is however observed that the withdrawal of the instant petition shall not preclude the petitioner to approach this court if the petitioner is aggrieved by any decision of the respondent authorities. Yes, what is this?
Petition. That first writ petition is 766 of 2024.
How many?
There are two writ petitions. Two writ petitions.
766, yes.
Mining contract for a period of 7 years, which was
Ah.
quoted by the BTC.
Ah.
In 2021, we participated. We participated along with the private respondent. All these petitioners participated. Comparative statement was looked into by the BTC authority, and they found that my learned friend's client was the highest, 2 crores 7 lakhs. And my rate was below 2 crores 5 lakhs, 2 crores 5 lakhs. So obviously, he being the highest, so they decided on the basis of comparative statement to settle with. And accordingly, it was comparative statement which they have put the amount that was approved. Mining plan was prepared, mining plan was also approved. Absolutely, there was no problem. Because we were not the highest. So accordingly, it was settled with him. But subsequently, we came to know in the month of January 2024 that this was cancelled and they retendered again for the same mining contract. So we made an RTI, and we came to know from the RTI that in 5th of December 2023, a retender notice was issued by BTC. Absolutely no problem, they can. Now, we came to know that it is not widely published. We were not aware of it. Section 34 of the Assam Minor Mineral Concession Rule, 34, it indicates that it has to be published in one local newspaper. Any auction notice has to be issued, which was not done in the present case. And from the RTI, we came to know. And accordingly, we have moved this on the court. Now, our whole issue, now the rate which they have quoted is the second. What rate they have quoted? Because initially the reserve price was 28 lakhs, but the rate which was quoted is 2 crores 5 lakhs.
Huh?
2 crores 5 lakhs by then, 2 crores 7 lakhs by then, which was approved. Subsequently, they decided to retender and cancel it. Now, this second retender which was issued by the Bodoland Territorial Council, the reserve price was somewhere 19 lakhs, but the rate which was quoted was 19 lakhs something, odd amount. So basically, that was not the issue. Issue is that whether under section 34 or the Assam Minor Mineral Concession Rule, they have complied on. We have, number one, it is not our whole contention. Before the Honorable Court, there are two contentions. One is that a public notice, which was required under 34, has not been issued. And e-auction was required.
Now, what is the stage of the e-auction?
No, e-auction, they have not done it.
No, the second one. The retender, what did you go ahead?
Tender, they have gone ahead, and their whole case they are saying that we have published in one local newspaper.
If your lordship sees 34,
No, no, thereafter what happened? A retender,
Then
they
they
have
came to
given
the
it
court.
to somebody.
he came to the court. They have sent it for approval.
They have stopped it.
We have stopped because there is an interim.
So there has
order
been
which
no
has-
allotment.
No allotment. There is an interim order which has been passed.
So,
Now, number one, kindly see 34 by law.
Mr. Bora, have you done it?
The option, they admitted, they said they have not done it.
Now there is stay order. Nothing has proceeded thereafter, after the advertisement.
No, no, only an advertisement has been issued.
Advertisement is, there is interim order, there is an order for not to proceed with the tender, then it stays like that.
You are required to do by e-auction.
So you are not, we're not required to, e-auction is an option, but we have not, the PTC authority has, there is no e-auction has been done. Because that process, e-auction is a different process, which it had to be uploaded and that process is not yet started in BTC area. And only thing is that this advertisement is the issue. As per the concession rules, my lord, advertisement was issued. It had been given, notice was issued to the notice board and all other forest departments on notice boarded, and as well as the paper publication was done.
Paper publication done where?
Paper publication done. And the lordship will have to take up.
Which is the retender notice?
This tender notice, your lordship will find at page 52.
52. And where was it published?
9. At page 55 is a press notice.
The press notice.
Press notice
And it was published
on 9th, published on
On 8/12.
on 9/12 in the
at
newspaper.
56A.
56A. But if your lordship kindly see,
Hindi newspaper.
now what has happened interesting.
Hmm.
9/12/2023, they said it was published in this Bodos, that local newspaper.
Hmm.
We now kindly see 58. See 58. 58. See the 9/12, we got the original newspaper. If you see the down below, this publication is not there. Press notice is not there. Yes, that's the whole contention. Only for an eyewash. And we have the original newspaper.
This is the original 58.
Yes, 58 is a newspaper which we have collected.
And what is this at page 56A?
56A is the same newspaper. I know, my lord, I have an experience, I can show it. There is one judgment of this court. Fishery also did the same thing. Fishery to show that there is a newspaper publication, but when you get the original, you say there is no newspaper publication. Now one second. They have not commented anything on 58. No comment has been made.
Now the paper has been
the
represented.
original. Kindly see the
Who is
original.
the respond number 10?
I-
Who are you?
I am the settlement holder.
How did you get it?
On the the paper publication, the council for the paper is also there.
Oh,
Huh?
They have the original paper. Council is within the paper publication board. They have the original paper with them.
No, okay, but how is Mr. J. Ahmed involved?
because I also participate, my tender has been challenged. Well, I got the tender. I have been selected.
Or no work order has been issued?
Because of interim order is there,
No.
work order has not been given. And mining, all thing has been completed. madam.
Okay, now let us see both the newspapers.
Yes.
Why not 2021?
Yes,
my
give it
my
to me.
learned friend, my learned friend quoted 2 crore 7 lakhs.
And he quoted 1
Now
crore
he
and 80
quoted,
lakhs.
now on the second NIT, he quoted something 19 lakhs.
My lord,
That's-
on that time,
See,
point of
I
time, my
am
lord,
not
tell me
there.
kindly say,
I am
on
not
that
there.
point of time,
Can you
seminar
see the
tender,
original?
I quoted
This
2
is
lakh,
what-
yes, correct, 2 lakhs, 2 crore 7 lakhs. My friend's client has quoted 1 crore 81 lakhs.
But that is
1
the
crore
past,
81
that
lakhs.
is past month.
Past
That
month.
it has been, that
Because-
particular Mahal submit, yes. Now it's a different issue, man.
Now is a different, that has already been over.
This is the newspaper. And where is your newspaper?
That is
Let us see your newspaper. Get a CBI inquiry done.
Yes.
Which one is the truth of the same?
And my learned
This
friend is
will
saying,
open up many
no, my
issues.
learned friend is saying e-auction
Swami,
is not
Swami.
fair. My lord, kindly see 34. And the BTC don't follow Assam minor mineral concession rule. They are following
We'll
that.
go into that.
We also got a similar paper.
My lord,
Actually, give me another paper.
Huh?
The respondent's paper, the person who has get the benefit, he also had that paper. Want to put over?
Hello? Who is the owner of this newspaper?
we made
Borosa?
a party also.
Huh?
Respondent 11, we made a party.
You are the owner of this newspaper. Which is the original? Now, where is the page number 3? Which is the original? Which one did you produce? The one which has the lighter version of that person? Gahad Mantri.
Yes, that one.
Our record also, my reply also contains that the
Huh?
same newspaper. My record, my.
No, this newspaper is different. Well, what is this newspaper? This page number 3 is the case. Everything else remains the same except this. How is it possible?
My record, original record also contains this paper only.
No, your record will always contain this only. There's no worry with that.
How can petitioner collect it? We are also surprised. How can the petitioner collect that paper? Whether we are all collect the original paper.
We were not surprised how you have done it. That's why we are surprised. You could not have done it. And there is no comment on 58. They should have commented on page 58. Let us see where they made a comment. 58, where is the comment on 58?
So this news is somehow absent. Usha, what is this? This news is somehow absent. Everything is there except this news. The difference between this and that is the news.
First case.
Huh?
This is not the first case. There are other cases. My lord, fishery case also they does same thing.
It is okay.
No, my lord, same.
We are now in BTC.
No, I know. My lord, I took my judgment. I know that they will say.
The fort, the best in of which you were holding once upon a time. Okay. Let us put
Another newspaper.
One second, my lord. Kindly see, if you're watching, kindly see the Act 34 of the rules. 34, kindly see, my lord.
of the minor minerals.
Minor
Give it to
concession
me.
rules. Oh, I have got one more. That I copied. 34. 34, my lord. Public notice for inviting expression of so and so. Number 2, in addition to publication routine writing, e-auction under subrule 1 above, gist of such notice along with schedule for e-auction shall also be published in one daily newspaper having circulation daily. Now my learned friend is saying that e-auction we don't do in BTC area. How they have to do it? E-auction. They said, no, e-auction is not being followed. We don't follow the e-auction.
They don't do it.
How can they don't follow?
No. There is another communication issued by somebody finance rules. They
Finance-
say about if
And
it is
that-
more than a crore, then you need to
Yes,
something.
25,
Assam
there are
financial-
notifications,
My lord,
there are
my-
notifications.
There's a notification to
yes.
that. In fact, there were many other matters which had come up. Those were done with the fisheries and
Yes, I
all.
can recall there are 3, 4 notifications are there.
Hmm.
If the value is so much, then
You have to go for e-auction. Then
But as on that, my lord, e-auction is something different, which you have to take a portal, the permission, then the process.
that
has
is,
to be done.
if you don't have, don't do it.
E-auction, as on date, my lord, e-auction has not commenced, that process has not yet started, my lord. Because it had to be done, it had to be, there is e-market portal is there. That had to tie up with that and a process had to be done, it had to upload it.
Who does this? BTC.
Now, you have to tie up with the portal, when the government portal is there, e-market. There you have to tie up with the government of Assam and then the portal, their Amtron is involved and other associations are involved.
This is being done by the divisional forest officer. Who's the divisional forest? Forest you are.
Forest, my lord, it's the PTC.
Maybe you are forest. You don't have any tie-up with the GM portal or with the government e-auction? Huh? So you have a tie-up with Amtron. Why the BTC is not, are you excluded by the sixth schedule
Exclusion, I don't think.
from
so,
this
but-
aspect?
But thing is that the process has to be done. It is a,
If you don't do it, don't forget about having any auction. Don't do anything. But the question is whether can you go ahead with this without this thing, without this Amtron business? Because otherwise, unless the sixth schedule protects you not to do it, can you seek for an
seek for the
exemption?
tendering. That I need to get the instruction, my lord, I'll see it, my lord. But as on date, the e-process has not started in PTC. That's in on the affidavit, I have stated it clearly. My instruction is so that e-process has not started.
No,
Other tender.
However, not starting the process, but
Other-
can you be exempted? If you are not exempted under the
During the
sixth
sixth
schedule?
schedule, that I have to get the, I have to check.
Because the money, otherwise the money, if the finance would not release it, where's the finance? Any finance council? No finance council. The finance has a notification, categorical
are
notification to that effect. If I remember last time when I was taking a bench 4-5, then I remember. There is a specific notification that above this, it has to be by way of e-auction.
Well,
And
have a-
that is why what you do, you can make it small wise, 20 lakhs each.
Yes, yes. Below that particular notification.
Ah.
I will check up that particular notification. I'll get that.
So that is why you bifurcate it.
Well, I remember there is no why, because as your lordship has rightly said, you have to be exempted under sixth schedule. All laws are being prepared. At my time also BTC has prepared all the laws, but that has to be assessed by the governor. If you don't do it, then this act, they follow this act.
The
They
notice is
follow
under
all
the,
the act. Education Act, they follow, the Forest Regulation Act, they follow, all 40 departments
Hmm.
are under them.
No, if you follow them, if you are doing it under the provisions of the minor mineral concession rules, you have to follow
under
this.
act only, this notice has been issued.
No, you have to follow
Whether-
34(2).
Yes.
You cannot seek an exemption.
Whether there
If
is
you
a,
don't have, forget it. Here, there has to be an exemption that it does not apply for BTC.
I will get it from that, as well as that notification, I'll go through the notifications.
Why? You sit aside. Without 34, you can't.
That's all.
Maintenance. Why
Okay.
do we require to?
So we'll fix it day after tomorrow. In the meantime, I'll go through this notification as well as this schedule, whether it is 34 will be applicable or not.
Give me the earlier notice,
Earlier notice of
the
NIT,
first, no, earlier part.
they are also page 20,
No, the first where he quoted.
26, 26 is the earlier NIT.
Yes.
26. And they are quoted comparative statement, the lordship will kindly to page 33.
Writing in the tender schedule 1-4. P to the SC 1, 24 divisional part of 1.
33, comparative statement. 23.
33.
33 is the company statement.
Who is,
Manoj Narjari is the private respondent.
he quoted 2
2 crores
crores
7 lakhs.
for how many years?
This is per year, per annum.
Huh?
Per annum.
7 years.
It for per annum? No, no,
Kindly see.
for total 7 years.
7 years.
Annually.
Annually, no, for total 7 years. isn't it? Terms and conditions of will be applicable for dealing. Now, all the terms and conditions laid down in the Assam Mining.
But if the lordship kindly see.
Here it didn't definitely mention.
This annual contract.
Think how it's to be done. Anyways. So earlier it was
Earlier it was
Mahadev Brahma. You quoted how much?
me, 1 crore, 81.
Huh?
2 crore 15 lakhs. 2 crores 5 lakhs.
Somebody
check
quoted
2 crore 5
Mahadev
lakhs.
Brahma is who?
What is Brahma?
Mahadev Brahma is
He
different.
is not a petitioner in this case.
Jagadish is 1 crore 81 lakhs.
Section 1.
Here there is one person who quoted more. Something phenomenal.
Mahadev Brahma.
He quoted in 215 crores.
Yeah, 2 crores.
Oh, 215 crores.
And one
Yes.
Abul Sheikh, my lord, 2 crore 5 lakhs petitioner. He is one of the petitioners here.
He's a petitioner here.
Abul Sheikh.
He crores 2 crores 5 lakhs. And you quoted
1
2
crore 81
crores
lakhs.
7 lakhs. For 7 years.
Actually 7 years.
7 years.
But my
I-
friend.
My
Well,
lord,
it's
that is
okay,
1
for
year.
7 years.
Yeah.
This is for 7 years. Now you have quoted per year.
This is now the present NIT is after reassessment. Reassessment has been done. After the prices come down. Lordship will my affidavit in page number 75. Lordship will see that.
No, you awarded the contract to him.
Yes, but after reassessment, the price will not be that earlier one, 2021. Now it's different.
Understood. You awarded the contract to him for 7 years.
Yes, 7 years.
And after that, why did you go for retender?
Because my tender has been cancelled.
Tender has been cancelled because the earlier tenderer has failed to produce the mining plan. It had to be followed by a mining plan. Mining plan was not given to him.
So he failed to produce the mining plan.
Mining plan. Then
So
the-
you went for a fresh tender.
After reassessment, the price has been reassessed. I have reassessment, I have page number 75 of my affidavit, the reassessment done. They are involving two mahals, all page number 75 and except 2.
Yes.
The price has now come down. Value and the reassessment proportion will also come down.
Where?
So page number 75 of my affidavit.
Annexure 2.
Annexure 2.
With reference to the, I am directed to inform you the Board is pleased to approve the proposal for newly reassessment of the stock of mining Iman to be extracted from the Iman. So now it is, which Mohol we are concerned?
Now, first petition is Falakkata.
Falakata,
Falakata.
4.82.
Galabil.
Earlier it
20.
was how much?
Reserve price was 28 lakhs.
Earlier,
128 lakhs at page 32.
earlier how much? How much was the tender for which? Tender had to be issued. Yes.
And
Earlier it
32
was
kindly see.
Falakata
Palakara
is
28 lakhs. Reserve price.
4.9, sand was 20,000. 20,000 cubic feet. Now it is 10,400 meter cube.
Then
Cubic meter.
10,000 gravel.
Gravel is 260. Earlier there was no gravel. Now you have gravel of 200, so it is 2,600. So area quantity is lessened.
Quantity is lessened, we have been reassessed earlier because of all these quantities and the mining plan could not be prepared. Unless we have a mining plan, the entire tender will not. Cannot proceed.
No, but how do you take care of the situation of 34-2?
Your lordship will kindly see. I'll just give a reply short. Kindly see page 36 of the writ petition. Why my landlord friend is saying that the mining plan was not approved? Kindly see page 36
Approval of the mining.
to the DFO. Approved of mining plan along with progressive mine closure plan respect of so and so. Palakata. So this
That
was
mining
approved.
plan had to be to the BTC. That
No,
is
why
not
is
wrong.
saying that it is not really? It has been approved, this mining plan. And for reasons, okay, they may cancel it, but not for the reason that they are showing that mining plan was not approved. And the same person,
Mining plan,
same person now participate in a second NIT. We don't, they knew also floating of the NIT.
Who is response number 11? Or Steve? Response number 11, what do you say about page 58A in your affidavit? You are a party out here. What do you say
58,
about page 58A?
Not 858.
58A? 58. What do you say about page
56
58?
is their paper, basically.
Page 58.
58, 58.
Paragraph where you have mentioned
Yes. Paragraph. Paragraph 8, my lord. Paragraph 8. If you see last few lines, the tender was not uploaded in the website of Forest Department or website any respondent authority. The press notice shown to be issued on 8/12 and stated the same was published in so an edition being so and so. Petitioner have collected the same newspaper in addition, but the paper cutting supply page totally tally with the is not tally with the original paper.
Yes, what do you say as regards in paragraph 8? No, what is your reply? You're not concerned with other things. What is your reply to that?
So kindly see page 91.
Because this is something very serious.
Where
Huh?
is it? 91. Page 91.
This
Page
paragraph,
91,
this
four.
person who has filed their affidavit, what does it say about, you say only about paragraph 8 that a communication was sent to so and so. Have you denied? Why you are not denying page 58 or the contents of paragraph 8?
There was remediation.
What do you mean by rule 34(2)?
Yes,
In addition to the publication of notice in writing,
yes.
this is a public notice.
Yes.
This does not say about advertisement. 34(1) does not say about any advertisement. A
Kindly see
public
down-
notice of 21 days shall be published for inviting bids or conduct of open auction for the grant of mining, lease, contracts, permits, as the case may be.
Yes.
It's a public notice. It may be hanged out there in the offices, everything. It does not say anything about the paper publication.
34.
In addition to the publication of notice in writing, e-auction under sub-rule 1 above, the gist of such notice along with the schedule for year shall also be published in one daily newspaper having circulation in the area.
So notice plus in addition to that, my lord.
Yes,
One it has
no,
to
no,
hang-
but two will only come only in the case of e-auction.
Yes.
Meaning thereby there is no concept of any other public notice settlement. See, is there any other method other than by e-auction? Can you read two?
Yes, in addition to publication of the notice in writing, that means notice
Yes,
writing above.
which notice they will paste it
So,
in
yes.
the offices?
Yes.
E-auction under
E-auction
sub-rule
under
1.
sub-rule 1 above.
The gist of such notice along with the schedule for e-auction shall also be published in one newspaper, daily newspaper having circulation in the area.
And also be published. In addition to that, it shall
It is only in the case of e-auction.
Yes, it shall, no, this is kindly see, my lord. A public notice for 21 days shall be published for inviting bids or conduct of open auction
Hmm.
for grant of mineral lease, contract, permits, as the case may be.
Yeah.
Right. In addition to publication of it, that's number one also I'll say there is a violation.
No, it's okay. Number 1 is okay.
No,
That is a
number
public, they have done it. They will paste it out there in the offices.
Yes.
There's no quarrel with that. That is another aspect. But what do you say about 2? Whether e-auction would be, if it is not a case of e-auction, whether 2 will come.
In addition to publication of notice, e-auction under sub-rule 1 above. No. If it is not a case of e-auction, your lordship is saying, if it is not case of e-auction, whether one will come out, that's what your lordship.
Whether there is at all a requirement of issuance of a paper publication.
I have not followed it.
Normally, they can go for whatever may be settlement, then they will give a public notice.
Yes.
A public notice is maybe either put it in the public Gaubura and all these things or beat of drums or whatever may be this case happens. This is how a public notice is issued. However, in the case of e-auction, you are to publish in the newspaper
Yes.
because 2 says only about e-auction. Now, if they don't go for e-auction, is it requirement for publication in the
No.
newspaper?
No, what I submit on this point. In addition to publication of notice in writing so far as sub-rule 1 is concerned. Sub-rule 1, in addition to that. Now, this has to be followed. E-auction under sub-rule 1 above, a gist of such notice. along with the
Kindly see, there's a reason why. If you have that same book,
Yes, yes, the
Okay.
same book, yes.
see why this has happened. In addition to the publication of notice in writing, earlier it was not e-auction, it was open auction.
Not E-auction, right?
Open auction under sub-rule 1, the gist of such along with the schedule for the open auction shall also be published. So if it is in all cases of open auction, because earlier 1 says about open auction.
Yes, let us forget about the e-auction. It was the open auction.
1 only says about open auction. So open auction was okay. There was no problem with open auction if we have. But the moment you bring in e-auction, and they don't go for e-auction, how do you apply 2? Think about it. We'll have it on Thursday. You get the point? How do you apply? Because there's some mistake on the drafting of this rule. So you need to find out one thing, that notification of the finance, that they cannot go for anything other than by way of e-auction.
Other than by way of the auction.
This is how you have. Because that is why they amended it.
Oh, I know, my lord, that is the why. In kindly see, my learned friend has said, except in BTC area, all other mode which they do it is by only e-auction. All mode, your lordship, there will be no many cases. It is by an e-auction. This is what my learned friend is saying, that e-auction in BTC area is not
No,
required.
no. Therefore, you find out there is a notification wherein he says that you have to go for an e-auction for this particular thing. He also, Mr. Bora also had. Mr. Bora will assist this court to find out. That notification is there, which Mr. Arbor Pujari and all can find out.
have it, madam.
Huh? He has it. So once that is there, then he cannot go otherwise, because that is why the amendment was brought in. But this amendment, if it is done by otherwise by way of e-auction, 2 would not come.
Hold on, one particular line your lordship will kindly look into it.
Yes, no, I'm rising at 3:15. We have a reference. So we will again hear you tomorrow, day after.
The newspaper is with your lordship, the
Huh?
original 2 newspapers. The newspaper.
Oh, both of you keep it. These are too valuable. I don't know which is more valuable.
Yeah, that's why I'm showing it. For this conduct, the court was proposing to initiate a CBI inquiry.
Okay. Anyways, yeah.
But these are very serious, my lord.
Because
Very serious.
one newspaper, however, will be very valuable. Because the copies will be less. You see, I have also come from the bar, so I know how things happen.
My lord, there is an item 10, my lord. Can it be day after tomorrow, my lord?
Why?
Because there is a stay order operating in their favor, my lord.
Okay.
Item 10, day after.
Item 10, day after tomorrow. Matter having been heard at length, as part heard again on Thursday. Top of the list. Top of the list.
Stop it. 8 and 9.
Interim orders Australia shall continue till the next.